right, good evening, everyone. We're going to call the meeting to order. It's Bridgewater Township Zoning Board of Adjustment regular meeting Tuesday, November 28, 2023. Both adequate and electronic notice of this meeting specifying the time, place, and manner in which such notice was provided in accordance with the Open Public Meetings Act, NJSA 10:4-6. Specifically on April 19, 2023, proper notice was sent to the Courier News and the Star Ledger and filed with the clerk at the Township of Bridgewater and posted on the bulletin board at the municipal building. Please be aware of the Zoning Board of Adjustment policy for public hearings. No new applications will be heard after 9:30 p.m. and no new testimony will be taken after 10 p.m. If you're able, please rise for the salute to the flag. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If you would stay standing for a moment of silence for Subha Shamin, please. Thank you very much. Welcome back, Roger. If we can have a roll call, please. Here.
Here. Here.
Here.
Here.
Here.
Here. Here.
Here.
Here. Here. All right, thank you very much. Mr. Widley.
I'd just like to make a personal comment about Mr. Amin. I had the privilege of doing much work with him on different committees and stuff over the last 10 years or so, and he will surely be missed. I just want to say that, to extend my condolences over to Mrs. Amin. Okay. Thank you.
Thank you, Jim. All right, at this time, I'm going to open up the meeting to members of the public that would like to speak for or would like to speak on any land use issue not on our docket this evening. All right, seeing none, I'm going to close that portion. We have no minutes. We have one resolution. That's the Shaw. Here, Seathal, 202 North. Comments, changes from the board?
None.
Seeing none, can I have a motion, please? Second. Motion to approve Mr. Widley and Mr. Bongiorno.
Yes.
Yes. Yes. Yes.
Yes. Yes.
Thank you. All right, Mr. Silver, good evening. You're here on two cases.
Somerville Lumber, if that's okay.
That's perfect. Good to see you.
See you. Good to be here. Good evening, board members, board professionals, members of the public. My name is Michael Silbert, and I'm an attorney at the law firm DeFrancesco Bateman, located in Warren Township, New Jersey. And I have the responsibility of representing the appellant this evening, Somerville Lumber Company. As a reminder, this is an appeal pursuant to Section 70A, 72, and 74 of the Municipal Land Use Law for the purpose of appealing a denial issued by the Township Zoning Officer with respect to an application submitted by the appellant for a certification of nonconformity pursuant to Section 68 of the MLUL. As I'm sure the board recalls, Somerville Lumber appeared before this board back in August of 2023. Just some preliminary background information to refresh everyone's memory. So back in April 2023, the appellant submitted a nonconformity application to the Township Zoning Officer to certify that the appellant and the property have vested rights to principal warehouse uses structures, as well as those uses customarily incidental to warehouse uses on property located on lots 2, 3, and 4 in Block 234, such rights having pre-existed the adoption of ordinance number 22-30. And that ordinance 22-30 resulted in the prohibition of warehouse uses in the M1C zone, the zone in which the subject property is located. The appellant's Section 68 application was also accompanied by a zoning permit application for a prospective warehouse tenant that was going to lease a substantial amount of space that was formerly occupied by my client, Somerville Lumber Company. And the Section 68 application was denied by the Township Zoning Officer in a letter dated May 11th, 2023, since it was determined by the Township Zoning Officer that the principal use on the subject property was not a warehouse use, but was instead a principal retail use. Thus, the appellant was not entitled to the certification of nonconformity, and as a result of the denial, the appellant's zoning permit application was also denied, since, again, warehousing is no longer permitted in the M1C zone. At the August 22nd hearing, we presented 3 witnesses. First, we presented Mr. Paul Pettit, who worked for Somerville Lumber Company for over 4 decades. He testified to the authenticity of a number of photos that I had presented in a slide presentation. Our second witness was Mr. Dominic Caruso, who is a well-known and reputable builder and resident of Bridgewater Township, and he provided witness testimony with respect to his longstanding business relationship with Somerville Lumber, which we hope helped to highlight Somerville Lumber's business operations on the property. Our third witness was Mr. Jonathan Glick, who was retained by Somerville Lumber a number of years ago to lease and market the subject property. To conclude our appeal, I'd like to call our last witness, Mr. Jim Kyle, who is a professional planner. As stated at the last hearing, we felt that it would be helpful for the board and for Mr. Kyle to listen to the testimony presented at the prior hearing and then provide his professional planning perspective to the board in light of Somerville Lumber's other witnesses and in light of the presentation. So with that as a reintroduction to this appeal, and with your permission, Mr. Chairman, I would like to call our final witness, Mr. Jim Kyle, have him sworn. And
Robert, I just want to make sure on Mr. Glick's testimony, maybe you can help me out here, Rich. Did members of the public get to ask questions of him? I know we were running against the 10 p.m.
I think we started. We started.
I have in my notes that we did start questions. I wasn't sure if they were board or members of the public. I just want to make sure that members of the public do have the ability to ask questions if they so wish.
sure. I have the transcript in front of me, so I'm just going to make sure here.
Is Mr. Glick here?
He is here.
Could we just open it up to members of the public just to be safe rather
Sure.
than have a problem going forward?
Absolutely.
All right, members of the public, Mr. Glick testified on, he was a commercial real estate broker for 40 years, and he made some testimony that surrounded the historical primary use, the value of the property dropping without warehouse uses, historically marketed as warehouse as primary use. I don't want to go over all his points, but if any members of the public have any questions they'd like to ask Mr. Glick, now is the time to approach. Give us your name and your address. All right, seeing none, I guess we've satisfied that. Thank you.
Thank you, Mr. Chairman. Is it okay if I move forward with our final witness?
Sure.
Great. Thank you.
Would you raise your right hand, please? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And would you state your full name for the record,
Sure.
please?
It's James, last name is Kyle, K-Y-L-E.
Thank you, Mr. Kyle.
Sure. And the firm is Kyle McManus Associates in Hopewell, New Jersey. Our business address is 2 East Broad Street in Hopewell, 08525.
And if you wouldn't mind, for the benefit of the board and for the record, if you could just provide your credentials.
Sure. I have a Bachelor of Science in Environmental Planning and Design, which I received from Rutgers in 1996. I've been a practicing planner for over 25 years. I'm licensed by the state as a professional planner. I'm also a member of the American Institute of Certified Planners. Our office represents about 22 municipalities as their municipal planning consultant. I've also appeared before over 230 boards in the state, including past appearances in Bridgewater. I've also been qualified as an expert in planning in 3 vicinages in Superior Court.
And your license is current?
It is.
Thank you.
Thank you, Mr. Kyle. Sure. Board accepts you.
Thank you.
So, Mr. Kyle, I have a number of questions I prepared, but you can go ahead and start off if you have a presentation and go from there.
Sure, and my comments are fairly brief. I think the issue before the board is fairly simple. We heard pretty extensive testimony from Mr. Pettit at the August hearing, and really the question here before the board is whether the evidence that has been supplied in the testimony supports the notion that the primary use of this property historically has been for warehouse. And I'll just run through and kind of highlight some of that. And again, as Mr. Silbert said, we're here because there was a certificate sought related to Ordinance 22-30 from the zoning officer, which was denied. That would be a certificate of non-conforming use and also a zoning permit. So we're here to appeal that. And this comes to the board under Section 68 of the Municipal Land Use Law, which essentially says that if any zoning ordinance that changes and makes a use non-conforming, that use is allowed to continue. So we have the option within 1 year of adoption of that ordinance to go directly to the zoning officer to seek that certificate, which we did, which was denied. And then we also have the option to appeal that denial, which is the basis for our appeal. So the zoning officer's contention in his opinion in the matter was that retail use was the primary use of the property throughout the years. So as you heard Mr. Pettit testify to in August, essentially most of the structures that are on the property, and that amounts to, and we presented this information in the presentation, is about 76% of the site is actually used for warehousing of building materials. We also described how sales occurred. Some of it was occurring outside in another location, some of it was occurring on site, but a very small percentage of the floor area of these facilities was dedicated to actual retail sales. The majority of the space was for the storage of, as we heard, lumber. Material was brought in on train, on truck, stored for extended periods of time until a sale occurred, and then it was taken out to a job site or out to a client at that point. Very similar to how a traditional warehouse works. Material brought in, stored for extended period of time, shipped out to another location when a sale occurs, either a wholesale sale or retail sale. So I think the description by Mr. Pettit and the other witnesses of the way that this business operated supports the notion that the majority of the space that is here was simply used for the storage of materials, similar to what you would do in a warehouse. We also have, and Mike, we submitted the letter on November 17th, correct?
That's correct. It was a letter exhibit with a resolution dating back to 2002 for the approval from the planning board for the construction of a 7,000 square foot warehouse on the property.
Yeah, and I believe that's part of the board's record. So just to highlight some of the issues in that letter that Mr. Silbert prepared. So I think the zoning history and the approval history, how this application has been treated over time, whether through the planning board or this board, is relevant to the board's consideration. So, because it really paints a picture of how the township had viewed this use over time. So when we look at the 2002 resolution, it notes that the lumberyard is a permitted use within the underlying zoning district. Now, at the time, that was M1A. And retail uses were not permitted in the M1A district at that time. 2005, the ordinance was amended to eliminate the previously permitted building materials storage yard use. However, Somerville lumber at that point was allowed to continue as a non-conforming use. And then in 2006, the ordinance was amended again to permit retail as an accessory use. So, in other words, subordinate and in conjunction with the primary use that was occurring on the property. I don't think we necessarily know if that was intentional, meaning there was a recognition that there was some limited retail use that was occurring on the property, but either way, I think the testimony that was provided in August does support the notion that the retail component of the site, in other words, we talked about things that were on the floor for sale, what types of sales were occurring. That was not walk-in sales. So most people were not walking in off the street to buy a hammer or a 2x4 or a piece of plywood. It was primarily contractor sales, items were shipped from this location to job sites, were held for extended periods of time potentially, and there was also inventory that was stored, windows, we described there were doors and windows that were manufactured on the site and then stored for extended periods of time until they were sold. So that, to me, is consistent with, how the property has historically been used primarily as a storage use. So I think in this case, the nature of the business use that we described, the evidence that was presented was fairly extensive. I think the testimony of Mr. Pettit, an employee that was there for 40 years, well knew for 4 decades how the operations worked, gave the board a fairly good description of how that use occurred and what was occurring on the property. I think that's compelling. And the 76% figure that we presented as evidence based on the floor plans, 76% of the building area, which would be the vast majority of the space that's on the site, was really used simply for the storage of those building materials and inventory that was then shipped out and sold. So I think, again, based on the testimony that's been presented to the board, my professional opinion is that when we look at that evidence and we look at the nature of the use of these buildings in this facility, it essentially has been a warehouse operation, from the beginning. And it's been treated that way as you look at the zoning history, approval history of this through the resolutions, as Mr. Silbert outlined in his November 17th correspondence, does support that notion in how this use has historically been treated. So I think at the end of the day, again, the board is deciding whether or not that is factually correct and that the applicant is entitled to a certificate of nonconforming use to continue that warehouse use despite the adoption of Ordinance 2230. So essentially you're certifying that the use was warehouse and therefore is allowed to continue into the future based on the issuance, or really overturning the zoning officer's decision to make that finding. And I think that the evidence does support that, in my opinion.
Just a couple questions.
Sure.
So back in early August, you actually had the opportunity to walk the entire property, correct?
I did, every building in the entire site.
And so, putting on the planner's hat, you observed everything. In your opinion, would you say that the property was representative of an industrial property with accessory retail? Is that a proper classification?
It was. When you look at the nature of the construction, the storage systems that are present in most of these buildings, it's consistent with what you would see in a warehouse facility.
Thank you. And then, did you happen to take in at all the number of parking spaces on the property? If I suggested that there were approximately 60 spaces, would that sound accurate to you?
Roughly, yeah.
And do you think that 60 parking spaces would be able to accommodate a principal retail operation of that size and magnitude?
No, not based on current standards. And I'll say I don't know the township's exact standard for retail, but it's typically somewhere between 4 and 5 spaces per 1,000 square feet. So you would be talking about a significant number of spaces.
Turning to the joint municipal report, which was dated July 28th, 2023, is it fair to say that principal uses are highly integrated with accessory uses and vice versa, meaning that the uses complement one another, they're supportive of one another?
They are.
So do you feel as though that the applicant's burden should be to prove to the board that the retail use on the property was subordinate in size and scale to the alleged principal warehouse use on the property? What is the burden of proof to the of the applicant or the appellant to the board? What do they have to demonstrate?
Well, here in this case, again, it's related to, do you feel that the use that we've described and how that use has occurred over time is consistent with a warehouse use? So it's not necessarily, strictly the relationship between the retail component and the storage component that we're contending as a principal use. There's not necessarily a bright line test in this case, per se. So I think it's just, as we had described, the retail component, any retail sales that were occurring on the site were fairly limited. It was more a wholesale type of operation directly to a contractor where material was shipped out directly from this site to a wholesale customer. So that's, I guess in a way it's retail, but it's more consistent with a warehouse type use, which would be a wholesale operation that is shipped out directly to a larger scale customer rather than an individual retail client that might come in again and buy a couple of 2x4s and some nails and screws. So that was not really what these operations were historically.
Couple more questions. So, you obviously reviewed the letter exhibit. To your knowledge, are you aware of a history of the appellant ever receiving D2 variance relief for the intensification or expansion of a retail use, which you had stated was not a permitted use in the zone?
Correct. No, quite to the contrary. In 2002, that issue did not arise. So the point in the letter correspondence was that if it was truly a retail use at that time, any expansion of that would have required D2 variance relief from this board, and that was not the action that was taken in 2002.
Two more questions from my end. Would you say that it's customary for a warehouse use to store building materials?
Yeah, I mean, it's not necessarily relevant what's being stored. I think it's more the manner in which it's being stored. So again, the racking systems, the buildings are consistent with a warehouse-style building.
And then just to conclude my questions, in your review of that November 17th letter, did you agree with the conclusions drawn from that letter?
I did.
Okay. Thank you.
Sure.
Back to the D2. So there was never a D2 that was applied for at any time in the history of this property. So there's no expansion of the pre-existing.
No, and I think that's an important fact. So I, as a municipal planner, and certainly Ms. Doyle or Mr. Burr, if an application comes in and you're looking at it, that's the first thing I look at. Is the use permitted? What type of relief is really associated with what's before the board? And is it before the right board? I mean, in the case of Bridgewater, having a separate planning board, separate zoning board, it's always important to make sure you're at the right body. So that's typically analysis that I would undertake as a consultant, and I would figure the same would happen here. So there was no identification of the need for D2 variance relief to expand a non-permitted retail use.
Mr. Silber, was there in the letters that you submitted evidence of retail being granted as an accessory use? Because I didn't hear you, Mr. Kyle, testify to that. So I just want to be clear if that was true or not.
So in the letter that I submitted, I attached a resolution. I think that the 2002 resolution and then the resolutions that came after that all acknowledged the fact that there was retail on the property. I don't believe it ever acknowledged that it was accessory or principal. What was very consistent was that they acknowledged that there was building materials being stored on the property. And I don't want to give testimony, but the resolution speaks for itself in the sense that that was considered to be the principal use. Certainly not retail. Retail was never considered to be the principal use on the property.
Right. And so there was no formal granting or acknowledgement of the accessory use as retail? Because I got a little bit lost in the Oprah request you had filed and some of the letters I was reading. That's why I'm asking for clarification.
Well, if I could just clarify for a second. So the letter references ordinance number 06-24, which was adopted in 2006, and relates to a piece of property which, to my knowledge, consists of Somerville Lumber's property, what now is Lot 1, the DOT's property, and the Denholtz property. And that ordinance essentially permitted limited accessory retail on the property or within the zone, provided that it was subordinate in size and scale to the principal uses. So that ordinance, in my opinion, I don't know if Mr. Kyle would agree with me, but if the zone only consists of 4 to 5 lots and an ordinance is enacted to acknowledge the fact that there is accessory retail that's accessory and subordinate in size and scale to the principal uses, and I guess this is really a question for you. Do you think that's suggestive of the fact that the township is trying to acknowledge the fact that there is accessory retail on the property or in the zone?
Usually, I would think it would be when you have a limited number of properties within a zone. And these properties were a zone in and of themselves. So there were no other properties in the township that this would have been applicable to. So one would draw the conclusion that it was intended to acknowledge a condition that existed on the site at that time.
And would similarly permit those other lots, if they so engaged in a accessory use as retail, to do so,
Correct.
correct? So I think where I'm having a little trouble, though, is in the terminology that we're using. You're saying that the buildings in question were used primarily as a warehouse, and what I'm saying, perhaps a little differently, is that this business was primarily a wholesale distribution business and was perfectly acceptable to operate as such in the zone as it was described at the time. And so without the wholesale distribution business, all of these accessory buildings would have been something else. So I'm trying to differentiate between warehouse and wholesale distribution businesses that need to put stuff in those buildings so they can sell it. And I'm looking for a better definition, because should the board find that this is an acceptable use, are we declaring this a warehouse space as opposed to what it really was, which was a wholesale distribution that needed to store materials that would then be distributed to its customers?
Yeah, and I think warehouse and distribution are two terms that typically go together in my world. Generally, if you have a warehouse, you probably have some type of wholesale or distribution use that you're utilizing that space to store those goods for distribution. So you don't normally see one without the other.
Well, you might argue that there are warehouses that are simply storing materials for their clients, and sometimes they're not selling, other than warehouse services, those products themselves at all.
Yeah, that could be true in limited instances, sure.
So what I'm wrestling with, and I don't know, don't want to speak for the whole board, they can ask their questions, is what is it, if we should say that, yes, you can go ahead and continue to use the property as it had been used in the past, what are we really approving? Are we approving this property's use as a primary use as a, quote, warehouse, which would then set the stage for a lot of other potential activities? Or are we saying this was a wholesale distribution business that stored materials on site, added additional buildings as their business grew, and then from those buildings distributed the materials to the customers who bought them?
I think it's,
Well, I would address that by saying that you're saying that by saying it's a warehouse use, it opens the doors to other types of warehouse uses. That's what I'm interpreting. But the board is protected in the sense that if a tenant comes in and the use is considered to be an intensification, so if a tenant comes in and they have to construct 10 more loading docks because their warehouse operation is drastically different than what existed, the tenant has to come right back before this board, and they can't do it unless the board says, unless they provide the proper justifications for D2 variance relief. So I don't think that this is, I see your concern, and I think what you're saying is you don't want the appellant to have carte blanche authority to operate the property in any warehouse as it sees fit. But I think you're protected in the sense that, again, they have to come back if there's what is considered to be an intensification of warehouse use.
John, I agree with that interpretation.
Yes.
But bear in mind, they would come back as a D2, not a D1, so the legal proofs are somewhat different, right? Because they would be expanding a pre-existing non-conforming use as opposed to coming in for a new not permitted use.
They would need 5 votes for that.
Either way, it's 5 votes.
4 votes for tonight.
Yeah, tonight's
Full majority,
application is a
68.
majority vote, yes.
Thank you.
That was a great point, Mr. Silver. I mean, because I do echo those exact concerns, even though, and I'll save this for deliberations, even though I do think, and my question is going to go to this, that part of Bridgewater, the M1C zone specifically, I do think does lend itself to warehousing. Can you speak to other buildings in this neighborhood, maybe within a quarter mile, talk about their uses, and talk about how those uses compare to what the applicant is seeking and some differences in the building sizes, et cetera?
so these properties in this M1C, they're all kind of similar buildings. They're older, they're not modern warehouses. So Denholtz received approval to remove 4 of those buildings. I actually worked on that application with them.
That went to the planning board, correct?
It did, because that application was filed before that ordinance was adopted. It's funny, we filed the initial application and there was a request to actually take more of the old buildings down and make the building bigger because it's a more modern, nicer looking facility. Most of the buildings that are out here, so along Chimney Rock Road and on the property adjacent to ours, they're all very similar. They're older warehouse buildings. They don't have really high clear heights inside. In college, I played hockey at a place on Chimney Rock Road that was an old warehouse. They converted it into a roller hockey rink, and it was low ceilings, a lot of columns. None of the buildings are very large in size. They're all kind of medium size. I would say most are probably 50,000 square feet or less. I think the exception would be the UPS facility, a little closer to Route 28. But, they're all kind of older style warehouse buildings. Similar in size, I would say, on the smaller side, particularly in the modern marketplace.
How about residential? Do you have any houses in this neighborhood?
There are, no, not anywhere near here. I mean, you have to go all the way down to Route 28 and beyond to really have any residential housing structures that are close to these properties.
So based on your analysis of the area, the warehousing function you think is appropriate, and based on what other businesses are doing in this neighborhood, you think it's a good use of the space and it's an appropriate use of the space?
It is. I mean, it's what's happening in the majority of this area. If you look at this particular little pocket of Bridgewater along Chimney Rock Road, they're all primarily conducting the same uses, and it's primarily warehouse and distribution type use. There's some wholesaler. I think there's a stone. There might be some contractors that have occupied some of these spaces as well.
Historically, the Dental's property was operated in a very similar manner
It was.
to Somerville Lumber's, where they had accessory retail.
It was. Yep.
And in terms of the retail that exists, we have literally warehouse retail. We have Home Depot, we have Costco.
Right.
How would you classify those retail establishments within a quarter mile?
So most of those are consumer, I'll say normal consumer. So you going into Costco or Home Depot to buy, lumber products. And we had some discussions with the client that that's really the opposite of what their business was. Not that contractors don't go to Home Depot, but it's primarily, normal folks that need small things, not the type of business that was occurring here. But those are certainly things that are occurring as well. But those are more consumer retail rather than how this business was contractor-based, wholesale type sales.
I have no questions.
Okay. Any other members of the board?
Yeah, it would be safe to say that the retail component was a retail showroom component to the products and materials that they took in and out of the warehouse. And any members of the public that would have attended or been present there would have been likely with a contractor getting an idea of what was available.
Yeah, and I think that's how Mr. Pettit categorized it in his testimony. Not that you wouldn't get a normal retail customer every once in a while, but it was primarily a retail customer with a contractor to view products that they were going to use in a job.
All right. Bill or Scarlett? Hi. Questions?
Zoning Board, 2018, which cited the applicant's need for better signage for the retail function. And also to point out, it was mentioned that the DOT site, I just wanted to remind the board that used to be E&B Distributors. So, and they had a showroom and they sold from there as well.
Right.
That's all I wanted to mention.
All right, thank you.
I have no questions.
All right, thank you. All right, members of the public, questions? All right, seeing none. Back to you, Mr. Silbert.
Thank you.
Thank you.
So I think that I think what I'd ask the board to focus on is the size discrepancy between the warehouse functions of the operations on the property versus the showroom. And it sounds strange to say it, but to try not to conflate how Somerville Lumber made its money versus the actual function of the property. What predominantly drove the property was its ability to store and distribute materials on the property. At the previous hearing, we had stated that the showroom component, the sales office, that could have been located anywhere. Yes, for convenient purposes, it was located on the property, but that's not really what drove the property in what was known as the industrial park here. So I would conclude our presentation by, or our testimony here, by asking you to vote favorably on this application, and rest assured that if there's an intensification of the warehouse operation or the warehouse use on the property, that we'll be back.
Rich, why don't you walk us through Section 68 cases? I don't know if Bridgewater Township wants to put up evidence. If they want to put up their original letter. I mean, why don't you walk us through that?
So Section 68 cases are somewhat rare, but this board has now heard, I think, 3 of them in the last year. So, and really they're all the same as I mentioned before. It's a majority vote, not a supermajority vote. And essentially, it is an application where the zone has been changed, or the use predates what the current zoning is. And in this case, we know that the zone was changed about a year ago now. And so the applicant's seeking confirmation that their pre-existing use, which they deem to be primarily warehousing and accessory retail, is what the use was. And they're asking this board, based on the evidence that we've heard, to confirm that in what's commonly called a certificate of nonconformity. It's not really a certificate, it's a resolution ultimately by the board. The zoning officer denied their application, and as you heard, they were able to go to the zoning officer for that certificate because of the time period. The change of zone was less than a year from the time that they made that application. That was denied because the zoning officer felt that the retail portion of the use on the property was what was primary, and the warehousing was accessory to that primary. I think it's important that the board look at not just the layout of the property and the number of parking spaces, for example, that we heard, but also the history of the zoning. I think Mr. Silbert's letter and the information that he was able to find through his Oprah request, I think is very helpful, and the board should consider that. That in 2002, there was a planning board resolution that indicated that the lumber yard on site was permitted, and at the time, in the 2002 zoning, retail was not permitted, all right? Subsequently, the zone was changed to permit accessory uses, retail as an accessory use, but not as a primary use. And their conclusion, as we heard from their planner, was that happened because the zoning was essentially catching up to the use that was on the property in that area, and there were a limited number of lots in use in that area. So, in the other testimony we heard that there's train tracks to the property. Is that something that's consistent with retail or warehouse? All those things are for consideration by the board. And Mr. Silbert's correct that if the board were to grant their application, they could not expand their pre-existing non-conforming use without coming back to the board for a D2 use variance.
Rich, can they use the buildings currently as they are then,
Yes.
without coming back here?
Depending on what the use is, yes.
Scarlett, can you walk us through the M1C zone, what it is and what a permissible use is? Let's take a break. Let's take 10. All right. We'll see you back at, let's call it 7:50. Thank you. I think we're all here. Roger, can we get a roll call, please? Here.
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 Yep.
Here.
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 Here. Here. All right, thank you for your patience. Scarlett? Scarlett, can you turn your mic back on?
Yeah.
I think I turned it off. Thanks.
There we go. Thank you.
Green is good.
Okay.
All right.
The property is in the M1C zone, and the ordinance specifically identifies 4 lots in that zone, of which these properties are a part. There are principal permitted uses and accessory uses and conditional uses in this zone. And I think I'm going to read them all only because they relate. They relate. Principal permitted uses are several. I'm going to say them relatively quickly. Principal permitted uses are business, professional, and service offices and establishments such as engineering and architectural services, accounting and bookkeeping services, banking and banking-related functions, credit services, security and commodity brokers and dealers, insurance carriers and agents, real estate services, photographic services, advertising services, employment agencies, consumer and mercantile credit and collection services, printing, publishing, duplicating, mailing, and stenographic services, consulting services, and data processing. That's the main one. Then there are several additional principal permitted uses. Manufacturing, trucking terminals, essential services, multimedia production such as graphic design and web-based services, research labs and research facilities, adult medical daycare facilities, nursing homes and assisted living facilities, indoor commercial recreation, as well as a special economic development option, which is not applicable here. Now, principal accessory uses, other uses and structures customarily incidental to the principal permitted use. Public and private parking, signs. Here we go, limited retail. Let me repeat that, limited retail that is accessory to the permitted use, internal to the permitted use, and primarily intended to service the needs of the employees. The next one is warehouse uses, of course, has been deleted. Conditional uses, accessory retail services within professional business and research offices. Again, accessory retail services within professional and business and research offices. Childcare centers as part of professional business and research offices, and animal hospitals and animal kennels. And of course, the normal parking requirements set forth in 126, 169. So that is the current permitted uses as per the ordinance as it stands today.
Thank you very much. Scarlett, can I also put you on the spot for Township Ordinance 2230 and what that did and when that was enacted?
20 through what?
2230.
Ordinance 2230?
Yes.
Do you have a copy of it?
That was the Township Council voting on no warehousing as a
Oh,
permitted use.
all right, that was the council that took warehouses out of every zone in the municipality. That was just recently effectuated, yes.
Right. And basically, it was townwide. Every
Every zoning district in the township, they removed the permitted warehouse use as a principal use. They maintained it as an accessory use, but they took it out of principal use in every zone in the township.
Now, in your opinion as professional planner, why do you think the Township Council took that action?
I believe that the township responded to several iterations of documents prepared by the State Planning Commission, where they said that the municipalities throughout the state should immediately revisit their warehouse ordinances because it could have great impact on their community.
That was the September 2022
That,
recommended document from the state, from Trenton?
that's
outlined
correct. The
that?
State Planning Commission sent that out.
Thank you.
Scarlett, can I ask you a question about when you read it? You brought a trucking terminal.
Yes.
Wouldn't that require some sort of like warehousing?
The trucking terminal could be, it could be argued that the trucking activity is involved in, as an accessory use, the warehouse.
Right, because they're not, most of the time that we've dealt with them is they'll pull in, leave the stuff there, and then it gets dispersed out to other
Correct.
trucks going, could sit there for an hour or it could sit there for weeks.
That's correct.
And that would be some sort of warehousing to me.
It's a fashion of it, but it is not part of the warehouse definition.
Okay.
Anyone else? Any questions for our planner? All right, Rich. So we covered section 68, what the hearing is. Have we satisfied all that we need to satisfy as a board for that hearing?
I believe you have, and other than any further discussion among the board members and those items that I mentioned before,
All right,
you can deliberate that. I do want to point out, too, just so Mr. Silbert is aware as well, I have signed certifications from Mr. Gajewski and Mr. Fresco indicating that they've read the transcript, they're listening to the tape, so they're eligible to vote.
Great, thank you.
All right, we're going to, if you're finished, we're going to open up deliberations unless, do you want to add anything post-Scarlett?
Yeah, the only thing I would just add, just to clarify, is that I referenced an ordinance back in 2006. It was ordinance number 0624, which at that time amended the zone to permit, and I'm quoting, limited retail uses subject to the requirement that they are accessory in size and scale to permitted uses. And that ordinance was then amended into its current form. So when Scarlett read the definition of the way that retail is permitted on the property, essentially to serve employees within the existing buildings, I just want to clarify that wasn't always the case, and that I wanted to make sure that the board's aware that ordinance I referenced, number 6-24, was amended. But at one time, it was permitted simply as an accessory retail use, provided that it was limited in scale and size compared to the principal use.
Thank you. All right, if nothing further, I'm going to open it up to the board for deliberations, and Mr. Wadelli, can you open us up?
Let me see where to start here. I've lived in Bridgewater for a little over 30 years, and back many years, my wife and I would often go to Somerville Lumber to purchase items for the house. This is before the Home Depots came in and took over everything, the Lowe's and everything, where you basically go now. So when you go in, as we've described this whole thing over this meeting and the other one, was that you do go in, there's retail. There was a round area, and 6 or 8 employees would sit there, and they wouldn't get up, they'd just point you where to go. So yes, the majority, it was not that big, but we could get what we wanted. We did cabinetry, all that type of stuff there. Then I would purchase what I want, and they'd give me a slip, and I'd have to drive around the back and drive into the area or park, depending on how much stuff I was getting. And you go in and pick it up. And there was all tons of stuff stored. There were several buildings. They tell you to go to A, B, or C, whichever one to pick it up. So we go do that and load it in the car, go home. So what I'm trying to get at is, if you go back there, the way the employee who was here last time spoke about it is, I tend to agree that it was a warehouse. So at this point, I would vote in favor of the fact that, approving your, to appeal the change of the decision.
Thank you. I agree with Mr. with Delhi. I think Mr. Pettit's testimony, he's an employee since 1974. He really spoke to, what happened at the heart of activity at this establishment. We established that 76% of the square footage was warehouse and approximately 21% was retail, with about the balance 3% being used for office space. He talked about the 10 tractor trailers that would arrive daily. In addition, the railroad tracks, that's a wholesale function. And then Mr. Caruso, I think that was, I was skeptical at first, and I thought his testimony really spoke to when a house is built, especially, multiple houses, how essentially the materials are stored on site at Somerville Lumber, and as each house went up, they went back to Somerville Lumber, and those products were delivered. I think the zoning officer in this case was 100% correct, and I hope that they take action, because, and the reason I asked Scarlett her opinion on Township Ordinance 2230, because at the spirit of that, I think was a reaction, and I think it was the right reaction to an inundation of applications in Bridgewater by warehouses. I'm guilty, most of us are guilty of buying things online, and logistics, the nature of that business is a warehouse-centric function. I don't think that type of warehouse is what's desired in this location, and if it is, it's an intensification, and Mr. Silbert made a very strong point that it would have to come back before this board for a D2. So this is a long-winded way of saying I'm definitely in favor of this, but I really want to put on the record that the zoning officer really did the right thing here. We needed to have a case, we needed to have evidence, we needed to have witnesses, which, the zoning officer should have no business being involved in. Absolutely did the right thing. I'm glad this came to the board. I'm glad we got the benefit of Mr. Silbert and his witnesses testifying that. And Bridgewater is inundated with these cases, and they don't belong everywhere. They don't belong next to senior living houses. They don't belong next to places that there currently are applications, and we want to protect those residents. So with that said, I'm going to be voting in favor. Mrs. Amin, good evening.
The way I look at this application is that the building has been used for so many years as a warehouse, not recently. Our rules in the township have changed back and forth, going back 20 years ago, when I read this application thing, it was allowed and then not allowed and allowed and not allowed. So technically speaking, this building has been used as a warehouse for 78 years now. Why do we have to deny this application when they are going to be using it for a similar kind of purpose, warehouse and whatever else? So I'm in favor of voting yes for this application.
Thank you, Mrs. Mr. Prescott.
I like Jim. I recollect as a kid, I might be a little younger than you, Jim. I was in the back of my father's station wagon, and we would go there. We built a deck and a shed, and we ordered the stuff, and then we drove through, which I remember thinking was the coolest thing. Simply put, it's always been that way. I am convinced by the case. And I had the privilege of listening to this case for the last 3 hours today, so I'm probably the most the freshest with the August testimony. But I am convinced that it's a primary warehouse, and that the retail, I feel, was accessory. So I too do support this as well. So
Thank you. Mr. LaSpiza.
Thank you, Mr. Chairman. I'm a little bit maybe more torn than my colleagues on this one. I know that we've been focused a lot on whether storing materials that you're selling is warehousing or a retail operation. And from my perspective, and maybe because of my background in insurance, I think about how we would insure such a property, and I think would underwrite it primarily from a retail risk, and with the accessory risks that go with storing the materials that we're selling. So maybe from my professional background, that's why I maybe am having a little bit of a harder time, because I think that's how an underwriter would look at an operation of a lumberyard. And But at the same time, the township has basically ping-ponged the use of this property over decades. So it certainly seems like we've already got 4 folks leaning yes. I'm not really sure what I'm going to listen to the rest of my colleagues here, but I am torn on this application because I think that just because you're selling to contractors primarily and not necessarily Jim or Andy's dad as your primary customers doesn't necessarily mean that it's not a retail operation. So I'm a little bit torn.
Mr. Bongiorno, good evening.
You've heard a lot of expert testimony. We've read through some of the ordinances. I'm still not sure I know what the differences between a warehouse and a distribution center is. But given that this is an industrial area, I'm inclined to support the application.
Mr. Gajewski, good evening.
Good evening. Yes, my understanding and knowledge of Somerville lumber over the years, it was absolutely used as a warehouse facility to store all of the building materials, and the primary clientele that were there were contractors. The retail component of it was, in my opinion, accessory use, and I would be in favor of this application.
Thank you. Mr. Seacat, good evening.
I'm a Bridgewater resident for 25 years. I'm familiar with Somerville lumber, and I've been a past, client or customer. I agree with the historic portrayal of the way the business has been, described. And this is really just, in my mind, granting the approval for a grandfathered activity. So I would be in favor.
Thank you. Mr. Gulak.
I would also urge the board to approve the application. I would caution, however, that the terminology we use is very important. So we're asking for permission to continue to operate as the business or property had operated in the past. We are not saying that you are a, quote, warehouse, and even if you do come back for an intensification of use, you're coming back as a something other than a warehouse, because I think setting that precedent perhaps creates more value in this market for that property than you're currently asking for. And I'm not suggesting you would do that, and I am suggesting, or I am acknowledging, as Mr. Silbert said, you'd have to come back for an intensification of use, but I would definitely support allowing the property to function as it had done in the past.
Mr. Vesio, good evening.
One of the examples brought up today in previous testimony was comparing this property to Home Depot. I think that's a fair analogy in today's 2023, but however, from looking back sort of the 1980s and before, I think one would always shop at one of these type of establishments for raw materials. I see the resolution that was provided earlier this month, and also the ordinance that was written in 2006, weighing those two things. I do believe that the property did have a warehouse use as more of a principal use than the retail establishment. So I would side with the applicant in this manner. The site is bound by 287, Route 22, and really the only access you have there is by the frontage road that will lead to Chimney Rock Road. And as just a retail establishment in this location, I don't think it has the proper frontage for such. So I think this property was used more as a warehouse type facility. Thank you.
Thank you very much. Based on what we've heard, Rich? Oh. You have more than the ability. I apologize. I probably should have let you testify before deliberation, so we can open it back up.
Absolutely.
Please, by all means.
There's just 2 items I want to make the board aware of with the question of primary, do I need to be sworn in?
Yes. Raise your right hand. Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Just for the record, Roger, just state your full name, please.
Yes, it's Roger Dornbeer, and I am the zoning officer, certified zoning official for the township. So 2 items. One, I know the question is the focus on warehousing or on retail? There's 2 things I just want to share with you. Number one, on April 10th of 2018, an article appeared in My Central Jersey about Somerville Lumber rebranding itself as Somerville Home Center. So I'm just going to pull some information out of the article here. On June 2nd, Somerville Home Center will celebrate a grand reopening that officially will launch the rebranding, including a redesign of logos and decor, as well as remodeling that features a new facade and signage. The new image reflects a refocus that will raise even more about awareness about the multifaceted business that is being run there. One of the quotes is, "Some people don't even know that we do kitchens under the Somerville lumber. So now under the home center, which incorporates the lumber, as well as all these other areas, people can say, oh, I want a new kitchen, I want a new bathroom. I can go over to Somerville Home Center rather than the lumber yard." There are other items in here I could reference. We service the entire tri-state. We service builders, remodelers, homeowners. We service everybody. So with this concept, we want to try to make it a little more appealing to the masses on a level of new. Somerville Lumber will continue to supply building supplies to builders, remodelers, and homeowners. Let me see if there was anything else. I don't think so for that. The last item would be in the testimony at the last meeting. Mr. Lehrer referenced the complete book of development definitions. We call it the Moskowitz book. And the term lumberyard has been, between the previous meeting and this meeting, been used at least a half a dozen times. I wish to provide you the definition of a lumberyard. A retail establishment whose primary products include finished or rough-cut lumber and lumber products that are stored on site. That's all I have to offer for your consideration.
Thank you as always, Roger.
Thank you.
So with respect to the newspaper article, I would just caution the board that, to the extent there are quotes in there, it's technically hearsay to the board. The board's not necessarily bound by the rules of evidence. We have lots of leeway, as you can tell, just by the way testimony comes in sometimes. But I would just caution you with the truth of anything that might be in a newspaper article, having been
So we shouldn't
misquoted
believe
almost every day of my
everything we
life. Sorry?
We shouldn't believe everything we read.
Don't believe everything you read in the newspaper.
Mr. Aller, obviously, the appellant hasn't had the opportunity to review that article in advance of this hearing either. Just wanted to point that out for the board, so.
The only thing I'm going to add to my deliberations, and Roger, thank you, and I apologize for not letting you put that on the record sooner. 2230, Township Ordinance 2230, was designed to stop warehouses, and it wasn't going to stop them unless they came to a land use board. And I still believe that the right outcome prevailed, and that we heard evidence. We heard essentially a briefing by both sides, Bridgewater Township and Mr. Silbert and his law firm, on why warehouse function existed side by side with the retail function. So, if anyone else wants to add to the deliberations, now is the time. Otherwise, I'll entertain a motion if anyone has one. We have a motion to approve?
I move.
Okay. Mr. Fresco made the motion?
I'll second.
All right, Mr. Widley? Mr. Fresco, a motion to approve?
Second,
No, I did. No, widely. I'm
I think
second.
Jim snuck in there. Approve.
To approve the application for the issuance of a certificate of nonconformity.
okay.
Yes.
Yes.
No.
Yes,
Yes.
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 All right, Mr. Silbert,
Thank you.
don't go anywhere.
You're still
Thank
You need 5 minutes to confer with your client?
So, I think that's all I need.
All right. We're going to go quick recess, 5 minutes. The time is 8:20. Let's come back at 8:25, and we'll pick up Mr. Silbert.
Here.
Yeah.
Here.
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 Thank you. Oh, Mr. Silbert, you're still here.
Still here.
All right, let's do some gateway.
So, I don't know if it's necessarily for the record to introduce myself again, but Michael Silbert, I'm an attorney at the law firm DeFrancesco Bateman, located in Warren Township, New Jersey, and I'm here on behalf of the applicant this evening, Gateway 70B LLC. Gateway is appearing before this board this evening to request a second extension of time for a prior approval in accordance with Section 126-73 of the Township's Land Development Ordinance, as well as in accordance with Section 52D of the MLUL. On October 19th, 2021, this board granted preliminary and final site plan approval with variance relief and design waivers to Gateway for property located at Block 221, Lot 1.01, as shown on the official tax map of the Township of Bridgewater, more commonly known as 229 Adamsville Road. Subject property is located in the Township's M1B Limited Manufacturing Zone District, and the approval was memorialized by resolution on December 7th, 2021. As many of you probably recall, back in May 23rd, 2023, the board granted the first extension to Gateway in a resolution memorialized on July 27th, 2023 for an extension of an additional 12 months from the original expiration. And the original expiration date was December 7th, 2022. So I'll refer to that as the first extension, and the first extension is set to expire this coming December, on December 7th, 2023. Just a little brief background information. So Gateway intends, in accordance with its approval, to demolish an existing building on the property in order to construct a new two-story medical office building with parking both around and beneath the building. Unfortunately, and as was the case the last time I appeared before the board, despite Gateway's diligent efforts, a wetlands permit from the DEP has not been secured as of the date of this hearing, and with the first extension set to expire next month on the 7th, the applicant here is seeking an additional second extension for a period of 6 months to commence on the expiration date for the first extension. And that would bring us to June 4th, 2024. So 6 months or 180 days. I don't know if the board needs me to go through any of the variance relief that was granted previously, but
You could just go through Scarlett and Bill's letter here. I know Scarlett had four points. She submitted a letter November 21st, 2023. And take your time. Just comments on the request. She has 4 notes here. And you just addressed number 1, so you're good there. She wants to know, are there any other outstanding items that have yet to be satisfied, other than New Jersey DEP?
so I think, I haven't reviewed all of it, obviously, but I think the other items would just be the completion of the compliance binder. I think that the Gateway has proceeded forward with everything they possibly can at this point. Obviously, they want to pull building permits as soon as possible. So, to my knowledge, that's the only outstanding item.
All right, that was number 2. Number 3, why don't you give that a quick read?
For purposes of tonight's hearing, I would welcome communication between the township's planner, township's engineer, to discuss this further with respect to whether or not the applicant would entertain certain easement dedications.
I'm going to ask you to do that sooner than later because unfortunately, and it breaks my heart, we're losing Scarlett as our township planner on December 31st. Is that your last day? Midnight, December 31st?
December 31st for what?
Last day, employed.
Yes, it is. Midnight.
Midnight, yes. We might call you at 11:58.
Mr. Byrne, I have a comment to make on number
Please.
2. And that is, once they do get the approval from the state, they're going to want to move quickly. And this has been languishing a long while. The compliance binder has not been submitted. Now, we don't let them submit the compliance binder until all of the approvals have been secured. But in this unique circumstance, Mr. Burr and I would be willing to review the compliance binder and get it poised for an immediate approval once they get their DEP, if the applicant wants to do that. Now, the applicant doesn't know we're saying this tonight, and it is against our policy, but in consideration of what they've been through, I think it's reasonable.
We would gladly, I welcome that.
Okay.
That's great. Thank you.
Thank you. Now, on to number 3. I mean, maybe that's something you could address in the next couple weeks with a letter back and forth, and,
Sooner.
Scarlett and Bill, they raise a very good point. We've been inundated in this part of town with applications, including pending applications in front of this board. So traffic considerations are real, and we do want to make sure that there's no problem with this application relative to what we've heard in updates of other.
Absolutely.
So you're going to submit a letter to her?
Yes, I will correspond either by way of email or letter as soon as possible.
Maybe you could put number 4 in there as a closing paragraph, just to reaffirm all representation made in the last 2 public hearings, requirements that were imposed in the resolution for the site shall continue to remain in force.
Yes.
Great. All right, so we need a vote, a motion on this?
No, I just want to say for the record that Mr. Silbert did notice the hearing, so the notice form was adequate and published timely and served timely. I see there are no public here for this, but notice was done, and the board does have jurisdiction to hear it. As you heard, it was an original approval for preliminary and final site plan granted on December 7th of #21, which was subsequently extended through December 7th of '23, and their request now for another 6 months brings them to June 4th of '24, all of which is within the MLUL extension time periods.
Do I open this up to members of the public to speak for or against?
Yes.
Okay, all right. Any members of the public that would like to speak for or against the 6-month, 180 days extension? Now is the time to approach. Name and address. Seeing none. We're going to vote on this. How many votes do we need for?
Yeah, majority.
All right. Everyone have any comment? Yeah, Jim? I'll move. All right.
Second.
Any comments on deliberations before we make a motion? All right, seeing none, we have Mr. Wadelli making a motion, yes, and that was Mr. Lestine. On the motion to approve?
Yeah, I was just going to say, this is the property we talked about cleaning up the last time. It seems to be in much better shape than it was the last time we had a conversation about it, so thank you, and please keep it that way as we wait for DEP to get off their butts. And, yeah,
You still want a second?
that's all I got.
You still a second?
Yes.
All right, we got a second. Yes.
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 All right. You have a third case, Mr. Silver? You're good. All right.
You said not to do.
All right, good seeing you. Thank you. All right, next up, we have CX Towers. 719 through 202, 206, do I have that correct?
Route 202.
Thank you. Mr. Purcell, good evening.
Evening.
We go through notice, jurisdiction, we'll talk about some housekeeping issues before we get digging into
So,
it.
Mr. Chairman, the applicant did submit a notice. It's in proper form. was mailed on November 16th, published on November 17th, all within the proper timeframes under the municipal land use law, so the board does have jurisdiction.
So, as per Bridgewater Township Wireless Facilities Ordinance 126-something, which I don't have in front of me, we have a right to retain an RF engineer. And I think you've been through this with Mr. Aller, and I just want to make sure that any testimony or witnesses you bring forth tonight, bring them back to the next hearing. I don't think you're going to be able to complete this case by 10 p.m. tonight. We want to make sure that our RF engineer has the ability to cross-examine any witnesses or ask any questions of any witnesses you present. Okay with you?
That's fine. We were just going to do engineering testimony tonight. We're not really going to get into RF, and the engineer will be here at the next hearing if your RF expert has any questions.
That's great. Our RF engineer, who I'm sure you know, is Hank Menkes. He's been employed by this board as long as I've been on it. He's great. He retired. He's moving south. We found out 2 weeks ago, unfortunately. So, as we interview and retain a new council, we'll let you know who we bring in to help us out. And I appreciate you understanding and working with us.
I appreciate you guys preemptively looking for someone. Unfortunately, it didn't work out, but I do appreciate you guys doing that even before the hearing.
We spent the last week and a half, finding people, and it's tough this time of year to find somebody, but we will, and
Okay.
we'll let you know who we bring in.
Well, thank you. Thanks. So my name is Ed Purcell. I'm an attorney at Price, Meese, Shulman, and D'Arminio. Here tonight representing CX Tower Leasing, T-Mobile Northeast LLC, and Dish Wireless LLC. CX Towers is also representing the interests of AT&T as a proposed tenant on the subject tower. And what we're proposing to do is to place a monopole on lot 6.01, block 183 of the township tax map. So just a few words about what's being proposed and what testimony will be provided tonight to the board. So first, what is being proposed? Each one of the carriers is currently on the water tower, except I should say for Dish Wireless, as will be discussed tonight. Dish will be located on the water tower, which is located on the subject property, probably beginning in January, as a temporary matter. Ultimately, the carriers, that's all of the T-Mobile, Dish, and AT&T, are being required to leave that water tower per the requirements of New Jersey American Water. The carriers would be very happy to stay on that water tower, but unfortunately, American Water is requiring them to leave. So what's being proposed is really to consolidate and maintain the infrastructure on one site. Applicants are proposing a 160-foot monopole as a replacement for their current location on a 103-foot water tank. So we'll be providing testimony with respect to height. So the driver with respect to the increase in height really has to do with that existing water tower and having the ability to clear that water tower for the provision of providing services. Having said that, we may be able to lower the tower as proposed, and we'll talk about that tonight, and we'll continue to have that discussion with the board going forward. Now, with respect to the property, it is particularly suitable for this site, and we're going to provide testimony on that with respect to RF. One thing to say, and I think we've had this discussion before this board enough times where I think you probably understand that cellular, like cell phones, cellular coverage, it comes the word cell is important. And the word cell is important because the way that wireless networks are designed, that there has to be a series of interlocking cells, almost like a honeycomb, that provide coverage over a wireless provider's coverage area. And each one of those cells has to interlock with every other cell. And in 2023, most wireless carriers have mature networks. So what that means, and we'll be providing testimony on this, is that it's difficult to shift a facility a far distance without impeding service. And this location, the location that we're talking about today, is optimum for the provision of service. And part of that has to do with the topography of the site. the water tower property is located on the crest of a ridge. And you may have never noticed this, but when you leave the Somerville Circle and you head towards Branchburg, as you pass Randazzo's Bakery on your left and there's a Shell gas station on your right, there's a hill that begins to go upwards. And ultimately, at the crest of that hill is the area where this water tower property, the subject property, is located. And from that point, the hill begins to decline towards Branchburg. So that height is an important factor that applicant is going to be presenting to this board with respect to why this site is particularly suitable with respect to this tower. Because obviously it's better to be on top of a hill when you want to provide service than below a hill. I also should say that the subject C7 zone, the commercial enterprise zone, is a commercial zone. There are residences in the zone, but the zone itself is commercial. Another important factor about the property that we're going to discuss is that there are trees on site that are helpful in screening the proposed facility. You know, I've lived in this area my entire life. Up until recently, I didn't even really realize there was a water tower there, and that is a product of the fact that there is excellent screening, excellent coverage by way of trees on the subject property. And while those trees would not be covering the top of the tower that we're proposing, they would cover a majority of its base. I also want to discuss a change in the law, because certainly that's an important aspect of any cell tower case. So there's two standards here. There's the municipal land use law, as you're well aware. There's also the Federal Telecommunications Act, or TCA. And previously, the TCA stated that a municipality prohibited or effectively prohibited wireless service if carriers could show that it had one, had a substantial gap in service, that a carrier had a substantial gap in service, and two, that the means that it sought to fill that gap were the least intrusive, the values that the local ordinance sought to protect. And that's what's called the APT Pittsburgh test. You may have heard that discussed from time to time.
Can you say that again, please?
It's called the APT Pittsburgh test.
EPT Pittsburgh.
Mm-hmm.
Thank you.
And that required a very muscular alternate sites analysis. So in July of this year, the Third Circuit overruled that APT Pittsburgh test, that decision that set forth that test that I just went over with you. And that case is called Selco Partnership v. White Deer Township. And what happened in that case was that the the Third Circuit adopted the FCC's standard for material inhibition under the TCA and did away with that APT Pittsburgh test. And the test that exists now is really a reasonableness test, that a denial would violate the TCA if it would prevent a carrier from operating in a fair and balanced regulatory manner. And that would be a violation of the law as it exists now. And I just say that because I think it certainly is a change in the law, and as we discuss this case, it's something that the board should be aware of.
Mr. Purcell, why even come to this board if FCC has jurisdiction on the local land use issue?
Well, you know, the TCA allows for local zoning to take place. There is a carve-out there, but you know, the FCC constrained that in 2018 when it adopted the materially inhibit standard, and the White Deer Township case applied that to the Third Circuit, which New Jersey is in the Third Circuit. So the process is the same. We still come to the board, but the law, the standard for a violation of the TCA has changed.
Mr. Purcell, you've been in front of this board 6 times, 6 different towers, including the replacement towers. And every time you've done this, I've called you out on it. And you know, maybe bully is too strong of a word, but I do want you to stipulate on the record that this board has jurisdiction, not you nor the FCC. And I want to make sure that's very crystal clear.
No, I agree with you,
This
Mr. Chairman.
land use entity, this zoning board of Bridgewater, has jurisdiction. Please don't bully this board with FCC and Third Circuit rulings, because it's not true. If you didn't need to be here, you wouldn't be here. It's a very expensive process, I'm assuming, correct?
Well, we do need to be here. I don't disagree with you, Mr. Chairman. I'm just explaining what the law is.
Every time you've been here, I've called you out on it because you bully this board and you start your argument the same way every single time. Don't bully my board members because I'm going to call you out on it, and it's 10 of 9, and we'll spend the next hour and 10 minutes talking about it.
Okay.
Don't bully this board. We
Not
have
my
an
intention,
attorney
Mr. Chairman, it was not my intention to bully the board. I apologize if that's your perception of what I'm saying, but I take your point and I'm willing to, move on with our testimony. Just by way of housekeeping, as I mentioned with the chairman, we will be providing RF testimony, but we're going to wait until the township has retained an RF engineer. And tonight we'll be presenting engineering testimony from Michael Martin. So with that, I'd call Mr. Martin up here.
I have a question. It says that the American Water Company has asked to move your equipment for homeland security safety concerns. I'm sure you asked what they were. Could you share those with us?
Yeah, we can get into, Mr. Martin's going to talk about that.
Raise your right hand, please. You solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth, so help you God. And your name, full name for the record, please.
Michael Thomas Martin. Oh, sorry. Michael Thomas Martin.
Thank you, Mr. Martin.
What's your background? What is your license or?
I'm a licensed professional engineer.
And Mr. Martin, have you been accepted by any zoning boards or planning boards in New Jersey as an expert in engineering?
Yes.
And what are those boards?
I have Warren Township Zoning Board and the Wanacue Planning Board.
Mr. Chairman, I'd ask that Mr. Martin be accepted as an expert.
What are
in
his
engineering.
qualifications?
You go over your
Yeah.
educational background?
Yeah, I have a bachelor's degree from Manhattan College in 2013. I'm a licensed professional engineer in the state of New Jersey since 2020.
Yeah.
And I've worked at Tectonic Engineering, the engineers for the site, for 10 years, doing majority of my design work has been in telecommunications.
Where's Tectonic based out of?
Newburgh, New York.
And you have a state of New Jersey license?
Yes.
It's in good standing?
Yes.
All right, we accept them, thank you.
Mr. Martin, let's discuss who is filing this application. So CX Towers, CX Leasing LLC. Now Dish and T-Mobile are co-applicants to this application, is that correct?
That's correct.
And AT&T is also a proposed tenant of CX on the tower, is that right?
That's correct.
And your engineering firm prepared the plan submitted to the board, last revised on October 24th, 2023, is that right?
That's correct.
And can you please review the existing conditions on the property and the surrounding area to orient the board to the location of the site?
I'm sorry to interrupt you, but before you do that, you said AT&T is a proposed tenant. They are not an applicant in this regard, is that correct?
That's correct.
Okay, so the applicants are, just for my edification
The
again?
applicants are CX Towers, T-Mobile, and Dish.
Thank you.
Is CX Tower, do they have a broadcast license?
They don't. They're a third-party infrastructure provider. The FCC has talked about that in its 2018 order, and third-party infrastructure providers that provide services to licensed carriers have the same rights under the Telecommunications Act and the 2018 order. So if that's where you're heading with that, that's the answer. Yeah.
So they don't have an RF license?
Correct. Correct.
Thank you.
So, Mr. Martin, can you just go over the property and the surrounding area?
Yep. Yeah, so it's on lot 6.01, block 163. There's a small 0.23 acre lot on the, that is near Route 202, the northbound side. The property is owned by New Jersey American Water, which operates a 103-foot water tank thereon. The carriers that are currently on the tank, which include T-Mobile and AT&T, are being required to remove from that location. Dish has received construction permits to temporarily locate their equipment on the water tank. They're going to begin construction on that after the new year.
Just stop right there. I know that there was, some question with respect to the status of Dish, and I guess that's why it was difficult to show that on the plans that they were in the process of going onto the water tower, at least temporarily, until this new solution is up. Is that correct?
Correct.
Okay.
I have a question. You're going to add somebody to the existing water tower.
Correct.
Is that correct? So
Yes.
I need to know what the Homeland Security safety concerns are that you're willing to add another carrier to the tower.
Yeah. So, Mr. Martin, I know we're going to talk about this later, but maybe just get into it now.
I'd like to hear it now.
Yeah. Okay.
Okay. Yeah, so basically, hold on, get where their wording is. Yeah, so to sum it up, given the need to constantly upgrade the transmission equipment, New Jersey American Water felt the changes were maximizing the structural integrity of the water tower. When the antennas were first placed on the tower in 2002, the weight of the antennas was much less, and there weren't any radio head frequency equipment up there. Over the years, the way the equipment has increased, along with the frequency, the number of equipment that you put up there, and American Water has decided that they don't want to have to deal with having these antennas anymore on the water tower.
And the Homeland Security aspect of it has to do with the access to the water tower structure itself by contractors.
Yes, yeah, there were security concerns related to contractors accessing the water tower.
But so that Homeland Security isn't concerned with the contractors being on the property itself. This tower would be acceptable. It's just that actually getting up onto that water tower, having people that can get through the locked facility onto the water tower was the concern.
Yes.
Okay.
Sorry, you kind of lost me there. So the distinction between the existing tower and the new tower is what?
The new tower will be in its own isolated fenced area, and the water tank will be separate from that. The contractors will not be doing work on the actual water tank, and it'll be.
Homeland Security was concerned about contractors going up on the water tower.
Yes.
Are they requiring these equipment to be removed, or are they recommending equipment be removed?
I believe they're requiring it.
Well, I think you can certainly, that's what, we're kind of getting all this secondhand because it's coming through the prism of American Water. So if the board wants more clarity with respect to exactly what NJ American Water is telling, what exactly Homeland Security is telling NJ American Water, we can provide that. We just have the letter from NJ American Water, which speaks to that, that Homeland Security, due to Homeland Security concerns, that they're requesting that these facilities be taken off of their water towers.
There's no contract in place with
Well, we can talk
Jersey
about
American
that too.
Water?
That's a part of discussion in our outline.
Did they give you a time frame when you have to remove these?
Well, yeah, that's a good, well, we can talk about that. So, Mr. Martin, is there a lease right now between the carriers and New Jersey American Water?
Yes.
And with respect to removing the site from the New Jersey American Water Tower, has American Water given a firm date?
No, they have not.
So basically, they said, we need to get you off this tower. We'll give you space on the property for a replacement tower. And once you get that approved, then you have to get off.
Yes.
Okay.
That's correct.
Okay.
Do we have a copy of this request from New Jersey American Water requesting that this stuff be removed?
We have a letter from New Jersey American Water to the board explaining why it's requesting that the facilities be removed. That was attached to the addendum in the application.
Gotta find that. Thank you.
Okay. All right. So, Mr. Martin, can you describe the property and the surrounding area? I think you just were talking about how it was located along Route 202.
Yep. The property is located on the back of Lot 6, which fronts Route 202. There is a residence located on Lot 6. The property also abuts Lot 3.
You just point to the plans? Yep.
Here to the south, where a residence is located and the Thermo Fisher Scientific Campus is located. And there is a ridge that runs northeast and southwest that bisects Route 202 in the area of our site. And the elevation in the area of the Wegmans to the southwest and the east/north side of Route 22.
Okay, so those areas are lower than the property, right? And then with respect to the Thermo Fisher Scientific Campus, that's in the M1 zone, is that correct?
That's
the
correct.
Manufacturing
Well,
zone?
the document he's referring to, is that what we already have in our packet?
Yes, correct. So let's, can you just speak to the dates on the site plan?
Yeah, so there was one error on the border of the site plan. They were updated to the 24th, but the border just wasn't updated, so it says the 16th.
Okay, and your firm prepared these plans?
Yes.
Okay, and these were the plans that were provided to the board, correct? Okay, all right.
We're calling this A1?
Would you like us to mark the
I
plans?
don't think
know
we need to
previously
mark
we
it
haven't.
unless the board wants to mark that, because we already have it in our packet.
Your call.
So I don't think we need to mark it. I just want to clearly identify it on the record as to what page he's referring to.
Oh, yeah, this is sheet SPO1.
And Mr. Martin, just be aware that there's cameras now and there's people on YouTube that are watching this. So when you talk about, you point, you need to kind of say this is the northerly direction and make sure a layman at home can understand kind of what you're describing and where you're at in different exhibits.
Gotcha.
And I would tell you too, were your plans submitted digitally?
They were, electronically as well.
Okay, because, maybe we can get them up on the board.
Yeah, your next time out, if you want to bring a laptop with an HDMI cable, you can broadcast and it can go out on YouTube and it can also go out on these.
It also makes it easier for the board to see, because everyone
now
has
have
a screen in front of them.
Oh, really? Okay, well then we'll do that the next time. That's a good suggestion. Certainly happy to accommodate that.
Yep.
I think I got the letter. Thank you.
Okay, great. All right, Mr. Martin, can you speak to the trees in the area?
Yes. There is a copse of trees around the property. It does help conceal the water tower from those traveling on Route 202.
And those trees would also help screen the proposed tower, is that correct?
That is correct.
And how tall are the trees?
They range,
Here.
about 50 to 70 feet tall.
Okay. And with respect to this site being on the top of a hill, is that a coincidence? Why would the water tower be located on the top of a hill?
Yeah, I think as you touched on in the beginning, for engineering reasons, the water towers need to be placed in higher elevation areas so that the water pressure could be maintained. This is a reason why water tower sites are often good candidates to place wireless installations. They are located above the surrounding area, not only because of the tower height of the water tank, but also because of the surrounding topography.
Okay. And do you know the distance from the water tower to the 7-story office building that is in front of the Wegmans on 202?
I believe it's approximately 1,400 feet, just
Okay.
rough numbers.
So 1,400 feet roughly, and it's located downhill from the proposed site.
Correct. It's about a 40-foot change in elevation.
Okay. And what is the purpose of the proposed tower?
The purpose of the facility is to provide T-Mobile, Dish, and AT&T with a permanent replacement facility due to New Jersey American Water's decision that the carriers can no longer use the water tower that exists on the property.
And, well, I guess we already went over discussing why NJ American Water wishes to do that. Are there any restrictions on the property?
No, there are no wetlands or wetland transition areas on the property. There are also no utility easements that would restrict the use.
An applicant has provided an environmental impact statement which discusses those issues, correct?
Yes.
And could you please provide a description of the proposed wireless communications facility?
Sure.
You might want to
That's probably it.
And just state for the record what sheet you're looking at.
Yes, this is sheet 7Z05.
Sorry, say that again?
This is 7-Z05 is the elevation plan.
Okay, can you go over the proposed wireless communications facility?
Yeah, the top of the approved tower is at 160 feet above grade, with each of the 3 carriers having their own center line. AT&T at 155 feet, T-Mobile at 145 feet, Dish located at the bottom at 135.
And it's a monopole design, is that correct?
That's correct.
Okay. And how wide will the monopole be at its base?
It's dependent on when they actually do the full structural analysis, but it's usually about a 6-foot diameter at the base.
And these towers are prefabricated, is that correct?
That's correct.
So at this point, you have a rough idea of what the model of the tower that you're going to use, but it's not definitive yet?
Yes.
So that's why it's kind of unclear, exactly how wide it's going to be, but you can approximate it would be 6 feet wide?
Yep, that's correct.
Okay. And what about the chain link fence that's proposed?
Yes, so going back to the site plan. This is sheet Z04. Then here in the plan north corner of the compound where the proposed monopole is going, we are demolishing some of the existing 7-foot fence with barbed wire and replacing it with a 10-foot tall fence with barbed wire.
No, but the applicant would agree to lower the height of the fence to 8 feet and remove the barbed wire, is that correct?
That's correct.
Okay, and in doing so, it would be compliant with the code of the Township of Bridgewater?
That's correct.
Okay. And can you talk about the dimensions of the fenced-in area?
Sure. Yeah, the fenced-in area here at the top on the north side of the compound is 35 feet across. At the bottom, it gets a bit wider as some of the fencing kind of follows a different, it's not perfectly square. It's 39 feet. And then running plan north and south is 31 feet.
So what's the total square footage?
1,123 square feet for the total for the lease area.
And what's going to be in that leased area?
The only thing that will be located in there is the monopole and its foundation.
Okay, and I know you're going to talk about this in a little bit, but the facilities that the carriers are going to use are located outside of that lease area, correct?
Yes, they will be running their coax and fiber lines underground to the tower.
Okay. All right, we'll talk about that a little later. Now, applicant proposes to landscape around the lease area. Could you speak to that?
Yes, as of right now, we are looking to provide 11 pieces of landscaping around the north and northwest compound.
And those will be arborvitaes?
That is correct.
Okay. And then there's a fence around, so there's a fence within the lease area, the 8-foot fence that we've just stipulated to lowering. And then can you discuss, there's an additional fence around the entire area, correct? Can you discuss what that is?
Yeah, so all of the individual carriers each have their own fenced-in areas. Verizon, AT&T, Dish has their platform down the southern corner. Sprint, which is being removed, has their own fenced-in area also in the compound.
Okay. And then there's a 7-foot fence around the entire water tower property, correct?
There's a 7-foot barbed wire fence surrounding the entire site.
So that's the first fence, and then you would enter through there, and then there's the carriers' equipment cabinets, which are fenced, and they're pre-existing, correct?
Correct.
Okay, and those
other than Dish, which is going to be.
And that's being proposed as part of their co-location onto the water tower, correct? The Dish compound?
Yep.
Okay, and then what's happening is that once the new tower is built, are all of those antennas going to be moved from the water tower over to the new tower?
Yes, they will.
And then all of the equipment that's on the ground will be used for the new tower, is that correct?
That's correct. Everything on the ground will stay where it is, they'll just refeed to the new antennas.
Okay. Are there any, how many feet from the tower is it to the closest residence?
So right now, from the northeast portion of our new little, it's 254 feet to the garage on the lot 6, and it's 270 foot from the monopole. And then the actual residence on lot 6 is 304 feet from the compound, 320 feet from the monopole.
Are there any external lights on the compound?
There are not.
Is there any, are there any?
No ground lighting, and then FAA analysis was done to show that we do not need lighting on the tower.
Okay. And then how often will technicians visit the site?
Roughly once every 4 weeks, technicians will need to visit the site just for routine maintenance.
Will there be
It's every 4 weeks for each carrier, or just?
Yeah, probably for each carrier.
Will there be generators on site when the tower is operational?
No, there will be no backup power proposed by the applicant or the co-applicants. AT&T, Dish, and T-Mobile do not have generators on the site.
Are there generators there now?
I believe Verizon might have one in their shelter. I don't know for certain.
Well, I was there today. There's 2 generators, and they were both running. I thought maybe they were in test mode. I was there for 27 minutes. They were running when I got there. They were running when I left. The prevailing smell of diesel was there. I'm sure they're going to run out of fuel at some point, but you may want to let your applicant know there's 2 Cooper station power generators running, and they were running for the entire time I was there today.
Maybe, again, we can go and check that. Obviously, American Water has facilities there too. They may have backup power, but we can certainly look into that. So
Something just for your own information. So you're planning no generators?
No.
In your equipment? Thank you.
I don't know, Mr. Purcell, if this is the time to ask this question, but it seems a fairly obvious question. We have not talked at all about Verizon. They're not part of this application. Is there space on this pole for Verizon? Should that change in the future? Are we going to have to see another application at some point? I mean, that's not a question for you, but
yeah,
where are they?
I can just say they're not. I can answer one of those questions.
Yeah.
Mr. Martin can answer the other part of the question.
Perfect.
So the first part is they're not part of the application. And then as far as can this tower accommodate Verizon? The tower as we're proposing, the 160-foot tower as we're proposing, could this tower accommodate Verizon, Mr. Martin?
Yes, the tower as we're proposing it is for 4 carriers.
Okay, and we can talk a little bit about maybe lowering the height if we, well, we'll get to there, but there's a possibility we could lower
Confirmation that it was a
if we
3
took
tail, yeah.
right, because we just have three carriers at this
I just
point.
wanted to add a question to that. Is Verizon not required to be removed from the New Jersey American Water Tower?
All of the carriers are required to be removed. Verizon is not part of this application. It's not, we don't know where Verizon is proposing to place its facility. It may be that it ultimately winds up here. They may be in the process of looking into where they want to go, but at this point, they are not part of this application.
Okay, so they are required to be removed from the water tower, but you're not anticipating representing them as a tenant of your new proposed tower?
At this point, with respect to the tower being as constructed, no, but it may be in the future that they may either co-locate onto a forced spot that if it's 160 feet, that'll exist, and Mr. Martin can talk about that, or if it's a lower tower for only 3 carriers, that if the tower is co-locatable, they could co-locate on top. But that's a discussion to have with the board when we talk about heights and possible revisions to the plans.
Well, you answered the first part clearly, and that is they are being removed from New Jersey American Water. The second part is a little cloudy because you don't have any definitive agreement. I understand that. Thank you.
Thank you.
Mr. Purcell, before you carry on, I believe you were the attorney for Verizon's small cell application, which I believe is going to be right outside this door, where Verizon has elected to fill in coverage gaps with a small antenna mounted on top of a telephone pole. Is that correct? Within the last year, you've been in front of the Township Council seeking approval?
Verizon did have an application. Well, again, I'm not a fact witness, but Verizon did have an application in the township, and sites were approved in this vicinity,
The
correct?
reason I ask and why it's relevant, is it possible that Verizon pursues a small carrier DAS type network like they've pursued previously in Bridgewater in multiple locations, including in Martinsville and across the street for the high school coverage?
Certainly, I'm not the RF expert. That would be a very good question when our RF expert is here. But they're not representing Verizon.
I didn't ask if the RF expert was going to testify, and I didn't ask an RF question. Have you been the attorney and represented Verizon in the small cell case in the township of Bridgewater?
Yes.
Okay. Is it feasible that Verizon could elect to utilize that same strategy which they're going to use across the street here and across the street from the high school and in multiple locations in Martinsville? Could a Verizon?
Mr. Chairman, that's an RF question that I'm not qualified to answer.
Is it feasible that your client that you represented previously could expand their Bridgewater coverage?
I can't answer that question because I don't know. Because I don't know what.
Okay, then
I'm not an RF expert.
why don't you
I
just
can't.
restate for the board, have you represented Verizon in Bridgewater Township on DAS cases?
Yes.
Thank you.
Along the same lines, can you tell us if you're aware of whether or not Verizon currently has towers across the street at the other office building?
We do. We will have RF testimony on that. I can proffer the answer is presently no, and that will be discussed by our RF expert.
Right, whether or not there currently are towers there,
Antennas, you mean?
antennas.
Yeah, she can talk about that. Those are, well, not to steal what she's going to testify to, but there are facilities there. And as far as we're aware, Verizon isn't on there right now, but let me let her provide that testimony when she provides testimony in front of the board. Where were we? So Mr. Martin, can you discuss how visitors will be accessing the site?
Yes. So visitors will access the site via a modified existing dirt gravel drive from Route 202 and park in an existing parking area adjacent to the tower. Shown on the site plan. You're on sheet SP01. So on the north side, on the northbound Route 202, you would come down this existing access drive all the way down alongside Lot 6, and then you would turn left to the compound on Lot 6.01.
Now, Mr. Martin, this facility has been here for quite a while. Can you discuss the status of the existing access road?
Yes. The site has been used by New Jersey American Water or its successor for roughly 64 years. The title shows an access easement across Lot 6 to Route 202. However, the existing road is not located within that easement. It has been extended into the Thermo Fisher lot next door. In preparation for this application, the issue was discovered, and New Jersey American Water is in the process of obtaining an access easement from the owners of Lot 6 so that the access road will be solely on Lot 6.
All right, let's just pause for a second there. So there's currently an access road on the site, correct? And you just described.
Correct.
Right. And right now, the access is from Lot 6.01 across Lot 6 onto Route 202.
Correct.
And what you're saying is that over the course of many years, that access road has pushed its way over onto the Thermo Fisher scientific lot. What's the lot number for that lot next door?
That one is, I believe, Lot 3.
Okay. So, so what is happening is the applicant also, and during the process of this application, came to understand that the access easement that it has for the property isn't where the road is located. It's on the other side of the property.
Correct.
Right? And the other side of the property is where there's a water main. Is that correct? There's a water main running along that other edge of the property?
Yes.
And then that means they really can't use it to drive trucks on, so that's why that site was never used for access?
Correct.
Okay, so that means, that explains why the access road is on the other side of the property, away from where the water mains are. Is that right?
That's correct.
Okay. So basically what's happening is that NJ American Water is going to be is in the process of cleaning up this situation, and the first thing they're doing is they're going to be getting a new access easement from the owners of Lot 6 for the, is that the north side of the property?
It'd be more the, the west side, like the
Okay,
west side of
the
the
west side,
access
okay,
road.
the west side of the property. So they're getting a new access easement for that site. And then they're basically, what they're also doing is they're moving the access road so that it's entirely on Lot 6, right?
Correct.
So we're not going to be touching at all the Thermo Fisher Scientific Lot 3. That's not part of what's going to be used at all.
Correct.
Okay.
Mr. Purcell, if one of those diesel generators that was running today catches fire, can a Bridgewater Township fire vehicle access this site?
So that's a good question. That was going to be part of our testimony. Mr. Martin, can you speak to that?
Yeah. So the existing access drive isn't as wide as New Jersey Fire Code usually recommends, a 20-foot wide access easement. This doesn't have it, but we have seen in previous applications that sometimes the fire marshal will go down to 12 feet, so like the width of a single lane road, which
What
is
is our fire
approximately.
marshal determined in this case? What is Bridgewater's fire marshal determined in this case?
We do not have that information yet.
Okay, so you know logistically how this board works. Safety comes first, whether it's, I'm not going to give the whole speech. I can promise you that without a fire marshal letter and fire marshal approval, I don't think this board will even vote on this.
Okay. So I know that there was a report from the township planner that spoke to some of the departmental comments. I don't recall there being anything from the fire marshal, but we will certainly follow up on that point.
Okay. So obviously, we're not going to finish tonight in the next 30 minutes. You have to have something.
Yeah.
And like I said, there's 2 diesel generators running. I know it's not your fault. I'm concerned. Wildfires do happen. I'll leave it at that.
Okay. All right.
I have resolution on there. So when I drove with my Jeep on that very narrow road today, I was trespassing, essentially, onto Thermo Fisher's property. And you're going to resolve that?
Correct. Well, Mr. Martin, essentially what's happening is this road is being shifted from where it is now to be entirely on Lot 6.
That's correct.
You're landlocked. Does American Water lease this from 719 Route 22? That's block and lot 163-6?
Yes.
Okay, and your intention is to bring this path or trail entirely onto that lot 6?
Well, I believe.
Well, it's not, okay, we're talking about the access, you're asking about the access easement, Mr. Chairman?
Yes.
Yeah. So the question wasn't, the question is, what is the legal mechanism by which that access will be provided? It's not a lease, it's going to be an easement, is that correct?
Yes.
So the whole lot itself, the .226 acres, who is that leased from? Mr. Scagliotta?
It's my understanding, having looked at the title work, that it's American Water that owns that property, the very small parcel.
Right, they don't lease it?
Correct.
Okay, and they have a commercial zone in that square surrounded by a residential zone surrounded by Thermo Fisher?
Well, it's the C7 zone is.
Or that square?
That little square, and then moving forward onto Lot 6 and then down Route 202, that's all C7. M1 is what's behind the site.
I'm assuming you're going to have a planner that's going to
Correct.
give further testimony.
Correct.
We'll leave it at that, but at this point, just my observation here, Mr. Scagliotta has you guys over a barrel. If he doesn't want to give you access for 20 feet, you're not going to get a fire truck back there.
It's a point of discussion between American Water and the Scagliottis right now. Certainly, American Water wants to see this done because this is the way they access their property. But it's something that's being discussed between the
As an
parties.
engineer, in your expert testimony, adding a 160-foot, potentially 4-carrier monopole tower, does that intensify the energy use, electricity use on that site?
The tower itself, no. The equipment and all the antennas are already existing, so it shouldn't increase anything else that's already there.
So the additional building, the additional cabling, the additional height, the new amplifiers, the new arrays, there won't be an increase in energy that's going to be served to that site?
All the energy that's currently feeding the site should be. I don't believe there's going to be any changes to the power going to the sites.
Thank you.
On that question that the chairman did have, are you just replacing one for one the current equipment that's on the water tower and putting that for one on the tower?
Yeah, that is the intent, is just to relocate everything that's on there to new mounts on the new tower.
Okay.
I don't know if this is your bailiwick, but I've seen towers that look like pine trees. Were you planning to do something like that because this is so close to 202, or you were planning a steel structure?
Right now, we're planning a steel structure, just a regular monopole.
Certainly, if the board wishes to have that discussion about making this to look like a faux tree or some other type of aesthetic treatment.
We definitely want to have that discussion, but safety comes first, and I really, I can't stress this enough. I mean, if we can't get a fire truck there, I mean, I don't even know why we're here, to be honest. It's 9:30 at night. If fire marshal says, no, I can't get a truck back there at 12 feet, why are we here? This is crazy.
Well, I can say, Mr. Chairman, that, obviously, as well as Mr. Martin said, the energy usage that's being proposed here is the same as what exists now, by way of the site that's been approved there since 1992. I've reviewed the resolutions for the site. This was not an issue that was discussed with respect to those prior approvals, but certainly it's an issue that the applicant takes seriously, that American Water takes seriously, and we're going to seek to resolve with the fire marshal and get that done.
Mr. Purcell, you've already stated that it's an error, the access road. So someone made an error, this board didn't make the error. It's 9:30 at night. If you're not going to resolve the error, you have a safety issue, and logistically, this board puts safety first. So clearly, your law firm has a different set of logistics than this board does. Again, why don't you just tell me what your plan is here? You're going to fix up this easement with Mr. Scagliotta, and you're going to hope to get 20 feet from him, and you're going to submit this to the fire marshal, and he's going to come back to us with a letter saying that a fire truck from Bridgewater Township can in fact access this site in an emergency.
Well, what I'm saying is that as a condition of the approval, we would obtain an access easement, or I'd say American Water would obtain an access easement for the site that we have the benefit of by way of our lease agreement with American Water, and also we would speak to the fire marshal to ensure that the width of the access easement is acceptable from his or her perspective.
Scarlett, what is typical for an access road on an easement such as this in Bridgewater? Okay, 12 feet? All right. Absolutely. The road is not suitable, and, frankly, I was in a 4x4 today, and I had problems getting out. Listen, I think we should break. I think you should go and talk to our fire marshal. I'm not going to tell you how to proceed with your last half hour here, but I certainly am not comfortable proceeding if a fire truck cannot access this site. Rich?
Mr. Chairman, since
Yeah.
I am not going to be here at the end of, I'm going to be retiring, I do have some comments that unless we carry this to sometime soon, I would like to be able to.
I'd like that too, so that's a good reason to continue, and let's do that. Let's use our
We had prepared to go over Scarlett's comments in our testimony, and we're just about the end of his direct, and then we'll go
Why
over the
don't we get a
comments.
quick stipulation then on the record? It sounds like, Bill, 18 feet is the less that you've heard. Scarlett, I heard 18 feet as well. Why don't we stipulate that this applicant has to have 18 feet?
So I need to go back and we need to speak to our engineer, and then there's going to be a discussion with the fire marshal. We can have that conversation at the next hearing with respect to, what the adequate width would be and what's acceptable.
Has to be in writing too. There's none of this that, it's based that we'll work with your town, we'll work with the fire marshal. You need a letter.
Okay.
And that fire marshal needs to say to this board that it's going to be safe, it's going to be accessible, and members of the public, because frankly, you have 4 residents right there. 254 feet, we have a garage, and 271 feet, you've got a resident. So fire truck's got to get there.
Okay. Okay. Just moving on, Mr. Martin, will any trees be removed from the site?
No trees will be removed.
And could you review the variances required?
Yes, so there's a D1 use variance for a use not permitted in the C7 zone, D6 height variance. 45 feet is permitted. We are proposing 160 feet. Front yard setback, 200 feet required, 28 feet are proposed. The side yard setback, 50 feet required, 25 is proposed. And the street access variance pursuant of NJSA 4055D-35.
And also, we need a, Scarlett called out a minimum lot area variance. The minimum lot area in the zone is 9 acres, and we're proposing 0.23 acres. So we're going to be requesting a variance for that too. Is that correct?
Correct.
Okay. And then also, we're going to be requesting a variance because the township code with respect to the conditional use for cell towers, obviously this is we're asking for a use variance, but for the conditional use requirements requires a setback of 120% of the height of the structure, and that's 192 feet, is that right?
Correct.
And we wouldn't comply with that, is that correct?
Yeah, all setbacks are less than.
And what are the setbacks?
The front is 28 feet. The side closest to access is 75 feet. The other side is 25 feet, and the rear is 72 feet.
And then with respect to the fence variance, that's been removed, correct? Because now we're compliant as stipulated at 8 feet?
Yes.
Have you reviewed the planning memorandum dated November 21, 2023?
Yes.
Okay, can we, let's review that?
Sure.
Comment number 4, asked to essentially explain the status of Dish Wireless. I think we've done that. So we'll mark that done. Number 6, will the new tower be designed to accommodate further antenna expansion in the future? Let's answer that now.
Yeah. So the tower, as we're proposing it, can accommodate 4 carriers now and is not designed for expansion. If the board wishes, the tower could be designed for only 3 carriers. If it is not designed to permit co-location, however, should another carrier wish to co-locate onto the tower, another tower would be necessary in the area.
Okay. The applicant's flexible there, correct?
Yes, yes, they're flexible.
What would the height be required for a 3-carrier monopole antenna there?
We would lower the height by 10 feet, so it would go from 160 to 150.
And then the monopole can either be designed to be co-locatable or not co-locatable, correct? So you could either add antennas arrays or not add antenna arrays.
Correct.
And as designed right now, is it designed to be co-locatable? Can you add arrays to the top of this?
As of right now, it's not designed to be co-locatable.
Okay, but
It's just designed for the 4 carriers.
But applicant would stipulate to lower it to 150 and then either make it the ability to co-locate so we could have a 4th carrier if necessary, is that right?
Yes, if we just have to stipulate that.
And then if the board wished that the tower not be co-locatable, in other words, that no 4th carrier could attach, we would agree to that too as well?
Yes.
Okay, but just the risk would be that if a 4th carrier wanted to locate on there would have to be another tower in the area. So that would be something for the board to consider when we get to that point.
And your engineer put testimony out that, and I know your RF engineer will cover this in depth, but the height of the water tower that's existing causes propagation issues? Is that why you need to be so?
Yeah, and that's something our RF engineer is going to get into in detail. I don't know, Mr. Martin really isn't an expert in that area, but that will.
He did reference it, though. He did say the height was predicated on that existing tower.
Right. But more than that, I think you'd have to ask our RF engineer.
Is there any chance American Water, now that they're giving you guys the boot, maybe wants to remove the whole tower? Their water tower?
I mean, that has not been part of the discussion at all.
If they were to remove this tower, would you guys be able to propagate your RF at a lower height?
That's an RF question, Mr. Chairman. I think we'll have to.
You're doing it now at 110 feet. Why couldn't you do it at 110 feet on a new tower?
You know, again, I don't really feel comfortable answering that question. I think that's more of an RF question, and I think an RF engineer can give you a very quick and concise answer to that question.
Okay, last question here is, what's the age of that water tower?
Age of the water tower, I believe it was, about 64 years.
What's the typical life of a water tower such as this?
That I do not know.
What's your estimation as a professional engineer, something like this?
Well, we can certainly look into it.
Yeah,
Get back to the board on that.
Yeah, we can look into it and get back to you.
Mr. Purcell, would it be prudent to ask American Water here if they are willing to take this tower down? It's approaching 65 years, a little long in the tooth, and that would maybe help us look at, your RF engineer could, possibly propagate this RF at a lower height?
We could certainly ask American Water if it'd be willing to take down that water tower. We can ask that question, and we can provide the answer.
I'd ask that, and, it's one way, because you're at 110 feet, and it sure would be nice to keep you guys at 110 feet.
Okay? We'll do that.
Mr. Chairman,
Please.
the last several cases we've been through with you, Mr. Purcell, have been temporary monopoles. So just for the edification of the board, is there some kind of boring that we need to do for this kind of monopole, or is it similar in design to the ones that we've done?
Oh, that's a good question.
So as far as like the foundation,
Because like
The background, they've been almost primarily dealing with ballast mount towers for the last number of years.
Oh.
So he's asking, this isn't a ballast mount. What is this by way of foundation?
yeah, so usually it would be a caisson, so it'd be a drilled shaft going down. They would need to do, once the actual structural analysis is done, know how deep and how wide it necessarily would have to be.
And this site was selected in consultation with American Water, knowing that there would be some kind of drilling, and the spot where you guys have identified to put this tower is suitable for that kind of drilling?
Yes.
Thank you.
The next question had to do with lighting. I think we answered that. Comment number 8, will there be any alteration to any component of the site after the antennas are replaced? In other words, will the compounds or other features be modified?
No, the compound as it stands will remain the same, other than where we're making the addition.
Okay. Comment number 9, will new fencing be installed around all of the existing and proposed equipment, or only around the new equipment?
New fencing will only be installed around the monopole area.
Okay. Number 10 has to do with the fencing. We discussed that, lowering it to 8 feet. Don't have to do that again. Comment 11, why is the barbed wire essential on top of the fence? What type of gate and security is being proposed?
Yeah, so as far as for the monopole itself, the barbed wire is not essential. We were going to remove it from the detail. There is barbed wire all over the existing site, so I don't know if it's something worth keeping. And then as far as access for the new bit of compound, I'm going to go back to...
But just to, Mr. Martin, just to clarify again, but the barbed wire is being removed from the proposed 8-foot fence around the monopole,
Yes.
correct? Okay.
Yes, from the proposed fence.
I'm sorry, I couldn't understand. Where is the barbed wire?
The existing perimeter fence around the existing compound is a 7-foot fence with barbed wire.
So that's an existing condition.
Barbed wire on top of a 7-foot fence.
Yes.
So it's probably 8.
Yeah, probably about 8 feet.
Right.
Thank you.
And that's an existing condition, correct? That's NJ American.
Yes, that's correct.
It's NJ American Water's fence?
Yep.
Okay. And then can you talk about the gate and security measures?
Yeah, so on sheet Z04, on the north side of the compound going into the monopole area, we do have a 6-foot wide access gate in the proposed fence. And that's how they will access the tower area.
And then will cameras be installed on the monopole?
Yes.
Okay.
Hold on, I have them on the elevation. On sheet Z05, we have these proposed cameras. The final height and location is still to be determined, but it will be somewhat raised above the compound.
And then each of the carriers also monitors their own equipment, correct? So if someone were to, mess with the equipment, that would be immediately known by one of the carriers?
Yes.
Okay. Comment number...
So how will they monitor their equipment? Will there be a central closet station where this equipment will be? Will they each have their own little space, or?
Yeah, so all of the carriers, other than the platform that Dish is proposing, all have equipment shelters. And most of the electronics in there are all wired with some sort of alarm so that if something is tampered with, it pings back to some network facility to let them know that it's been, like a fiber line has been pulled out or something's been, a cabinet's been opened.
So they all have their own little sort of closet space,
Yes.
and that's what their cameras are watching?
Well, I think I don't,
Cameras are, there's a camera on a monopole, correct?
yeah, the camera's on the monopole.
And then the monopole is, and that camera is viewing the lease area below the monopole.
Correct.
And then with respect to the equipment compounds, those are monitored remotely by the carriers.
Yes,
And those equipment compounds are located outside of the lease area, right?
correct.
Okay. What you're saying is that they have equipment that if one of those facilities is tampered with, there's an alarm that goes off and they immediately know it. And they
Yes.
can contact the police. Okay.
Or they send a technician, any,
Does that answer your question?
Yes, it does.
Okay. Comment number 12, other utilities often install black fencing around their compound areas where residences are permitted and within the site of the property. This application did not provide this. If approved, it is recommended that an attractive black aluminum fence be used.
Yes, given that the fact that the site is within an existing 7-foot fence and the use of landscaping to screen the site and its placement away from the roadway at this point, the applicant does not feel the need that black fencing is warranted. However, it may agree to, based on the board feedback.
Okay. So just as initial matter, the applicant doesn't feel like it's necessary now, but it'll be willing to discuss
Yes,
making that revision in the future if the board requests it.
yes, that's correct.
Let's discuss it, because we have the person that wrote this memo here, and we won't have the benefit of her being at our next meeting. So Scarlett, number 12.
Black fencing is something, whether it's decorative or not, black fencing, you see beyond it, and it doesn't stop your vision. So I think they should have black fencing, be it black vinyl-coated chain link, it could be, but it would be black-coated, or the decorative black fencing that you have like around the PSE&G facility on Route 22.
Right. And this is consistent with what we've done in other cell tower cases?
It is quite consistent with most commercial applications.
Thank you.
As far as, black vinyl chain link fence, is that what you were saying, Scarlett? Black?
That was my second.
Yeah.
As I see this, there is yet a perimeter fence around your.
Correct.
Is that right?
Right.
Yours plus.
It's a perimeter fence plus landscaping, which we're going to increase. We're going to get to that. Plus this, what you're talking about with fencing. So there's inside, so there's there's 3 layers.
Rather than having 2 chain link fences with the silver, it would be well to cut it down to 1.
You guys good with that?
Sure.
Okay.
Yeah, certainly we'll agree to that.
Item number 12.
Yeah.
Scarlett, do you want to just dive into your questions? We only have 15 more minutes, and
I think we can go through it rather quickly.
Yep.
Number 4, sheet 4 of your plans says proposed Verizon. So why does it say proposed? I got the impression that your application was for T-Mobile, Dish, and CX, and I'm curious as to why sheet number 4 says proposed Verizon. It's a detail. It says Sprint to be removed. but proposed.
Scarlett, which paragraph are you referring
It's in the
to?
design, it's in the detail. It's just written. So if that's not the case, it should be removed.
Yeah,
I think that might be a typo, Mr. Martin. I know these plans were revised and a number of times.
Yeah, there shouldn't be any mention of Verizon. Yeah, any mention of Verizon will be removed.
Clarify that then. The next one is based upon the next one is the species you have mentioned will be arborvitae. Those are in the plans?
Yes.
The height is not. Do I suggest that you have 8-foot high arborvitae? Would you go along with that?
Yes.
Okay. 8 foot, yep.
Yep. The The next one is number 18. We have discussed this access easement. I believe that this land is leased by New Jersey American Water from the Scagliatas. I think the best thing for the board to have information on, you need the access easement reviewed by our attorney. The access easement may have conditions that we didn't know about that preclude the use of the easement for anything other than water service. I mean,
Agree.
Attorney Aller should review that.
You'll provide that?
Yeah, applicant would stipulate to submitting the easement between, the proposed easement between American Water and the Scagliotis for approval by Mr. Aller.
Catch, thank you.
Okay, and I believe we've discussed the permanent easement that is being negotiated. There's an August 22nd letter from NJ American Water saying that they're trying to negotiate a permanent easement. Is that simply for the area that's off their property?
That is correct. So that's to have the access road entirely on Lot 6.
It says with the owners, paren, Scagliata. So they're not going to be negotiating with Scagliata. They're going to be negotiating with Fisher.
No. Well, again, Mr. Martin, the access easement is not proposed at all on Thermo Fisher's property, correct?
Correct.
The question that I think our attorney should collaborate with the applicant's attorney is whether or not the CX and the carriers must have their own separate leased portion. And that would be after he looks at the existing easement, see whether it's embedded in there that they have the right to use it or not. And that's quite important, obviously.
Yeah, Scarlett, I think what we were going to discuss with that is that with respect to the relationship between CX Towers and NJ American Water, its rights to that access easement are a product of its lease with American Water. And so what I would suggest is, in addition to having the access easement between American Water and the Scagliotis approved, that we would also provide a copy of the lease, redact the economic information, but it would clarify what rights CX Towers has to that access easement.
Okay, Mr. Aller, and then the only other thing is I believe there should be testimony on the fall zone based upon the concern that seems to have been raised about Homeland Security. There is obviously a fall zone, and not only will the tower be affected, but also the Scagliatas will be affected in that they can't put a structure in the fall zone, according to, I believe, the ordinance. So that should be a matter of discussion and testimony at the next meeting.
Thank you, Scarlett.
Thank you.
Bill, you want to add anything in there? Hard act to follow. It's like going on after the Beatles, I know.
Up to the board. I'm happy to go through, I have a number of questions. Happy to go through them now. I could wait till next time, whatever the board would like.
If we can get 10 minutes in, that'd be great.
So first question actually pertains to February 23rd, 2022 letter from New Jersey American Water. I don't know if you have that, Mr. Martin. You have a copy of it, Ed.
Which one is this? This
is the letter to Bridgewater Township from New Jersey American, February 23rd, 2022.
That's the one that's attached to the addendum?
The one you attached that you referenced is.
Yeah, I got it.
Okay. So I want to call you to two questions I have in the second paragraph of that letter. And the letter, that paragraph starts by raising some of the concerns that they have, including homeland security issues, security for multiple carriers, but then they mention breach of security by carriers and/or their contractors. Do you know what that means? as a reason for why they're asking you to vacate their facility?
That I cannot speak to. I'd say it would probably need one of the representatives from the carriers. I'm sure that's probably a conversation that they've had with them, but I haven't.
We have a representative from CX, if Mr. Aller, if you want to swear him in as a fact witness, Mr. Fassett can speak to that question.
Sure, why don't you come on up, raise your right hand. Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And state your name, please.
Eugene S. Fassett.
And spell your last name.
Fassett.
Mr. Fassett, what's your relationship with CX Towers?
I am one of the members of the partnership, and my official title is managing member.
So could you answer that question?
Yeah, so in terms of the communication that we've had from American Water while we were negotiating with them is that one of their big concerns is that with more complex equipment on the water tanks, some of the carriers, or one of the carriers, they just said carriers, actually cut the locks and climb the tank without American Water being there. That really, really violates their safety to public water concerns. So that is what they're referring to, and they told us it happened at multiple sites and has become a major issue for them.
So I have one question on that. I know we had testimony with fencing around your cell tower, but there's no testimony for fencing around the water tank. So what difference will it make? And security-wise, you'll still have access to the tower.
But the cell carriers and the contractors won't. American Water will still have access to their tank, but the carriers will be limited by fencing to only the areas that have to do with telecommunications.
They could still cut the locks like they did previously.
Right, but they could, but if there's they didn't cut the locks to be malicious. They cut the locks because they were frustrated and they wanted to get their equipment fixed and didn't want to go through the process. If they don't have equipment on the tower, there'll be no motivation for them to cut the locks and climb a tank that doesn't have equipment on it.
That's what Homeland Security is worried about?
Homeland Security is worried about unauthorized people being on the water tank.
Accessing telecommunications.
Can I have a clarification on that? It references a Homeland Security guideline. Could the engineer define what a guideline is?
That I haven't seen that. I haven't gone through that.
I think that's something we're going to have to look into and then get back to you on.
Sure, and can you reference like the official guideline in the next meeting? Thank you.
Sure.
So,
Along the same lines about security, you have equipment which is not on the water tower. That is, the individual carriers have equipment which is not on the water tower. But it seems to be near the water tower. How do they gain access to that equipment? The stuff that's on the ground, not the stuff that's in the air.
So how do they gain access to their equipment cabinets currently and going forward?
Yes, I believe they still go through the main gate, and then each carrier has their own fenced-in area.
Okay.
Hold on, did you or did you not say that the equipment on the ground was remaining?
Yes.
All the ground equipment was remaining, and they're going to rewire it to the tower?
Yes.
Okay, so it's all immediately, I'm looking at the other plan, it surrounds the tower, the water tower, correct?
Yes.
Okay.
So the access then is controlled how?
Is there another fence around the tower that we're not noticing on these plans, like a smaller net closer to the tower?
Yes. So.
Speak to what page you're.
Yeah. So we're on sheet Z04, and then so this is in the northwest corner of the compound where the new tower is going. Yeah. We're putting the new access.
I meant the water tower.
Oh, the water tower.
Is there another closer into the circumference of the actual water tower? Is there another fence that we're not seeing? I think that's the question we're asking.
Yeah.
Right? You're in the perimeter fence. You're getting access to the ground equipment. You're getting access to your tower. But what's keeping you from climbing the tower anyway? Is there another fence closer to the tower?
No, there's just the main gate, but the carriers.
The water tower.
Yeah.
I think,
So there's just to back up, so you've testified, Mr. Martin, that there's a 7-foot fence that NJ American Water has around the entire property, correct?
Yes.
And then there's an additional fence that is around the lease area of that, which surrounds the monopole.
Yes.
That's the question. Is that your question?
no, I'm sorry, my question is there another fence around the water tower? Because we're talking about,
Okay.
you have access to the site, right? And the concern was access to the water tower.
Yeah.
Is there another fence around the?
Yeah, so Mr. Martin, what is the protective device to inhibit somebody's ability to access the water tower once they're inside the first set of fencing? Are they unable to access that water tower?
No, because, once they're inside the main compound, that's the compound where the water tower is located.
Right, and is there a lock or a gate that?
Yes, there's a gate, and I believe American Water controls who has access to that.
To that gate to get onto the
gate
water
to get
tower?
into the water tower space.
Does that answer your question?
Can you testify, where will the equipment be serviced by the carriers? Could you show us on the diagram where the
Yes.
equipment will?
So in the northeast here, this is Verizon's equipment,
Okay,
and then AT&T shelter is in the southeast corner,
okay.
and then Dish's platform is located inside the main compound.
Inside the main compound.
Correct.
So they'll need to gain access to the main compound, which is in the proximity of the water tower, to service their equipment, yes or no?
Yes, as it's shown here, yes.
Can you also identify all the equipment along the southern border? Can you identify what all that equipment is?
Yes, so we have T-Mobile's equipment here in the corner.
Okay, will they need to service that equipment?
Yes.
Is it directly in the proximity of the water tower?
Yes, that one it's in its own fenced-in enclosure, but it's in the greater area of the water tower.
But it's
And
not,
east of that is what? I see some squares there.
Yeah, so that's the existing Sprint equipment that's being removed.
Okay. Okay.
Yeah.
Thank you.
But the people who are servicing those equipment areas have unfettered access to the water tower itself.
I believe they have to set up access through New Jersey American Water.
Now, what I'm saying is, can I walk over from my little fenced-in area and touch the tower without having to go through a fence?
As of right now, only T-Mobile and Dish have equipment inside the main area. Sprint's old compound, AT&T's compound, and Verizon's compound all have exterior gates. So the carrier has their own access to their enclosed area.
There are two carriers that have access to the tower. If they wandered over and decided, who knows why, to do something with the tower.
Correct.
Okay.
they can't, Mr. Martin, but they're unable to climb the water tower, correct? Because that is a locked area to climb the water tower?
Yeah, but I mean, once they go through the main gate to get to where their equipment is, then, they're.
The point is that a technician servicing equipment isn't going to want to climb a water tower for no reason at all, especially when there are anti-climbing devices on the tower. And the only tower climbers who will be on the site will be inside the area of the monopole.
I think that what's being questioned is that this is a requirement based on Homeland Security needs that's forcing you to do this when it doesn't seem true.
No, again, the
Homeland
motivation.
Security, this is-
The equip, what you have to understand is that these days, all the electronics are in the air. And that's what requires service and attention.
I understand, but it's saying that you have to come off of the water tower because of Homeland Security guidelines and concerns is forcing you off of this tower. And that's 100% true? That's the only reason that you...
No, if you look at the letter and Mr. Martin's testimony, that's part of the reason. The other part of the reason is just the amount of equipment that in 2023 now has to go up onto these towers as opposed to when these leases were entered into in 1992, and that's in their letter, that's increased exponentially, and American Water just doesn't want to have to deal with that anymore. And also having to coordinate regular replacements going up, going down. It's a secure facility. Right. Right, correct, and that's set forth in the letter. Right, because in 1992, there was certainly a lot less of that than there is now.
Mr. Gajewski's point, you haven't improved security one iota on this site.
That's not true.
Tell me how it's not true.
Because the only people that are going to climb a water tank.
In your example where they're cutting locks, they're still going to cut locks and have access to walk right over to
That's
the...
illegal, and it's a matter for law enforcement.
That's your testimony. You said that someone cut a lock and access. So how have you improved security to a kid that has a bolt cutter from Home Depot?
Well, obviously, you can't stop everything, but...
Wouldn't multiple gates prevent that scenario?
You can minimize who's going to have access to the tank.
Listen,
And minimize it to professionals that don't need to be on the tank.
I don't think you've met the criteria that you've stated that you're trying to improve security here because you haven't. You haven't added
we're not-
With all due respect, that it's not my opinion.
Well, just to be clear, we're not, again, the purpose of it is we're trying to locate these facilities onto a new tower to provide service. That is we're having to do that because American Water is saying you have to come off of our tower because we have Homeland Security. There's concerns based on Homeland Security directives and also issues with respect to their concern about the weight of the facilities and the constant replacement.
Mr. Purcell, it's 10 o'clock. I'm going to cut you off. I'm going to cut you off also, sir. Scarlett, do you have anything further? Because this would be your last appearance on this case.
No, that would be it. I've given the board comments on page 7. I've gone through the ordinance and commented on each one, and I would think that would be part of the need for more testimony, not by this witness.
All right. Mr. Purcell, we talked about the fire issue and the fire marshal, and I think the board has an interest in the Homeland Security side of this, and I certainly would like to hear that requirement and, how you're going to improve security on the site, because contrary to your CX managing member, I'm not sure that you've met that hurdle, that you're going to improve security. So maybe you can help us clarify that. There was some cloudy testimony, and kids with bolt cutters do happen. And I'd like to prevent that water tower from having any vandalism and something worse, God forbid.
Okay, certainly we'll work on that for the next hearing. With respect to timing, when are we thinking this would be? I know Mr.
Our
Maher
next
was
meeting
saying-
is December 12th, and we have Chimney Rock Storage, I believe. We have 3 cases that night.
The one that must be heard at least for some time is 1222.
Yes.
They have hit their limit, and we must hear them by MLUL.
Yep.
And we have Chimney Rock and Belly. Belly is a townhouse development in Mount Pleasant Villas area.
Sure.
And Chimney Rock is on Route 22, that's self-storage.
Is there a chance that Chimney Rock won't be back to us with new plans for the 12th, or do we think that they're going to?
Excuse me?
Is Chimney Rock going to definitely be back on the 12th?
I'm not going to say definitely, but the theory was yes, but maybe not.
Okay.
But the important thing is, I can't say it enough, 1,200.
That's more than a full docket. So our reorg meeting is the 9th, of which we have signature, which is a large warehouse case that Mr. Silbert was representing as well. Many objectors, many senior citizens
Familiar.
are interested.
Yep.
We don't have meeting dates, but they will be set at the reorg meeting, so we'll let you know what our
So we'll
schedule
carry
looks
it,
like for next
carry
year.
it to January 9, and then we'll carry it from that date to a date certain. Okay.
And more importantly, on December 7th, our Township Council is going to be having a proclamation for our own Scarlett Doyle, and I welcome us all to attend December 7th council meeting. I'll be there. And then at our next meeting at 6:30, a half hour before our scheduled start time, Bruce has been kind enough to arrange some cake and some refreshments for anyone that would like to join us, so we can say a fitting goodbye to our favorite planner. And with that, I'll see you on 7 p.m. on the 12th, unless anyone has any other business.
Let me just announce it. So for the public, this meeting's being adjourned. It will reconvene at 7 p.m. in this room on January 9th, 2024, with no further notice from the public, from the applicant. We have a question.
All right, and we'll see everyone on the 12th.
Mr. Chairman.
You have a question?
Unfortunately,
There will be a time for that, yes.
you will be able to ask questions of the witness at the next meeting. It probably won't be on the 9th, but we'll let you know the date on the 9th. I'll be sure you get adequate time to ask all of your questions, and then at the end of the case, you can speak for or against this application as long as you wish. January 9th at 7 PM.
Yes, but all that's going to happen on January 9th is they're going to get a new meeting date.
Because the dates for next year aren't set yet.
There'll be no testimony on the 9th. Right, a new meeting date will be set. No new testimony on January 9th. Only a meeting date will be established.
Our next meeting's the 12th.
Whenever that next meeting is, their engineer will most likely conclude. You can then ask questions of the engineer. You can also ask questions of the managing member, who should come back at the next meeting, because there was no cross yet of that, right? And you can ask questions of both of those gentlemen when they conclude their testimony. Okay? Yes.
Absolutely. Yeah, if you come into the land use office, come and get everything. Absolutely, they'll give you a copy. All right. Anything else? All right, thanks for coming. We'll see you next year. All right, get a motion to adjourn, please. All right, Mr. Widley and Mr. Bongiorno. All right, 7 PM, December 12th, party at 6:30 PM.
No, it's 6:30. Just tell people
6:30.
You tell them 7.
Yes, for Scarlett. It'll be in this room.
There's 7:30.
7.